Monday is night. Item 14. Today. Item 14. No, moi aji meeting is. Tuesday. Moi petition. I'm the pool age. Mr. Lordship.
Yes.
I beg to mention item number 14 from the hearing, part 2. Lordship, I have taken the consent of the petitioner as well as the government. If the matter can be listed on Tuesday, Lordship. Tuesday, coming Tuesday.
No objection, my lord.
Learned counsel for the herefore.
I'm for the AG, respondent number
10, Mr. M. Mozi is
10.
paid for listing the matter. What's the date? Tuesday. 16th.
16 years.
16th. Learned counsel for the petitioner and Ms. Such and Such has no objections. Yes.
Objection.
My lords, we beg to mention item number 26.
26.
My lords, it is a fresh matter, and this was supposed to come up for hearing for tomorrow, my lords. That is 12th of September. But my lords, inadvertently it has come up today. Senior counsel Mr. Diganta Das is specifically traveling for this matter, my lords. So we may request that the matter be adjourned for tomorrow, because other 3 matters are also tagged for tomorrow, my lords.
Other three matters, meaning,
Mr. Solo, can you apprise?
Your Lordship, other 4 matters are listed for tomorrow, Your Lordship.
or connected
Connected
matters?
matters.
Your Lordship, it can be listed tomorrow, Your Lordship.
Tomorrow? Okay.
Yes, Your Lordship. I'm appearing on behalf of ED, Your Lordship. Since the ASD, Mr. Raju, is also appearing in this matter, so this matter can also be listed tomorrow, Your Lordship.
Yes, my lord.
Mr. Such and such, mentioning on behalf of senior counsel, Mr. Das. Please give your name, Mr. Das,
Amit Singh, my lords.
who has made a mention for listing the matter tomorrow, as Mr. D. Das, senior counsel, is appearing in the matter. Stop.
Your Lordship, Ankit Khanna from ED, Your Lordship. ALA and SPP.
Mr. Such and such for ED, Mr. Kidovi for
SPP,
yes.
ED,
No, respondent number.
respondent number 1.
Respondent number 1. ED is respondent.
Yes, my lord.
Respondent number. ED.
There's only one respondent, my lords.
Oh, only one respondent.
Yes, sir.
Okay then.
Yes, my lords.
Please tomorrow. Pass over for the day. Yes.
Your Lordship, my
Much
appearance may kindly be recorded, Your Lordship.
I am appearing for the ED as well, my
Yes, sir.
lord. I'm the
Yes, Your
special
Lord.
counsel in the matter.
Give your names.
I'm Zohaib Hussain, and my lord, we'll assist
Ankit.
the file a response also.
Okay.
Ankit Khanna, Your Lordship.
Ankit Khanna.
Your Lordship.
Yes, done tomorrow.
My lord, any date,
Much
my lord,
obliged.
is fixed?
Tomorrow.
Sir, it is for tomorrow.
Tomorrow.
Can it be the day after, my lord?
Day after is Saturday.
The
So
senior counsel
or-
is coming from Gauhati.
Or
yes.
On Monday, my
There
lord.
is, sir, there is an urgency
Very good.
that so it can be kept for tomorrow.
Monday, only one day, because it's too short a time for us to put in a response, my lord.
So
Only one day.
we can fix it tomorrow after. We can keep it for Monday, but at least since Das sir is traveling for this matter, so we can keep it for tomorrow, and we can reconsider for Monday.
Only if we will be able to put in some response, my lord. Only
this-
one day's time. Instead
Motion.
of
This is coming up today for the first time. Motion.
correct, my lord.
My lord, it was supposed to come for tomorrow only, but inadvertently it has come up today, my lords. And since Das sir is appearing for this matter, he's already on his way. So it is a request that can come up for tomorrow, and then we can decide tomorrow itself that whether a date can be granted.
Is it on Monday? Okay. We'll
Monday,
see.
my lord.
My lords,
Thank
it's a request, my lords, since production
Only,
warrant is
Mr. Amit,
also there on
only
16th.
one day I'm saying. It's not a big.
My lords, Mr. Das is appearing in this matter. We can keep it for tomorrow, and then we can decide tomorrow that whether we can keep it for Monday
Mr.
as well.
Amit, let him not travel. Let it become. on
He's
Monday.
already on his way, sir. So it's a request. It can be kept for tomorrow, and then we can also decide whether Monday can be a date or not.
Only one day I'm
He
seeking.
can give you time. He can give you time, Mr.
Ma'am,
Kaushik.
my lords, there is an urgency, my lords. Since 16th, production warrant is already issued.
Tomorrow.
So there is an urgency for this matter.
Okay, fine. Tomorrow. Yes, tomorrow.
Much of.
Yes.
May it please, Lordship. Lordship, I beg to mention here in item 15. May I pray that this matter be listed after 3 weeks, Lordship.
15. Third Learned Counsel for the
For respondent number 4 and 5, Lordship.
respondent number 4 and 5, Mr. Such and such, who makes a mention for listing the matter when?
After 3 weeks, Lordship.
After 3 weeks. Any
I have no objection, Your Honor.
Learned Counsel for the petitioner, Ms. Lucina has no objections. List after 3 weeks. Yes.
If I may be allowed to make a mention of item number 22, my lady. My lady, this matter pertains to Longkhum village. So my lady might have difficulty in taking up this matter. So if
List this matter before any other bench without me. Learned Counsel such and such present for the petitioner and Learned Action AG for respondent, state respondent.
I'm for respondent number 3, 6, and 7. I, Jamir.
I, Jamir for 3, 6.
my lady, can it be after 3 weeks then if my lady can?
No,
No,
I'm
line-
here, yeah, this court is here for a month. So we'll just say it without me. Yes.
Oblige.
Obliged.
Please, Lordship. Lordship, I beg to mention item 5. Lordship, here I am appearing for respondent 1 to 5. Lordship, if the matter can come up after the Puja vacation, I'm yet to file my objection to the IA.
Okay. Learned Counsel, is there any such appearing for respondent number 1 to 5? Please give your name. Okay. Makes a mention and prays for how much time?
After the vacation, Lordship, Puja
Praise for
vacation.
listing after the Puja vacation in order to enable him to file an objection in the IA, condonation?
Condonation.
In the IA. So prayer is allowed. Learned counsel for the petitioner, for the appellant, Mr. Marhu, no?
Medovero.
Sorry, Medovero and Mr. Likase for?
For R6, my lord.
R6 are present. Yes, after Puja vacation.
Much obliged, Lordship. Lordship, I beg to mention hearing item number 19 and 20, Your Lordship. Your Lordship, here the leading counsel, Sir PP Paul, is on leave, Your Lordship. So on a consensus prayer, if this matter can come up on 23,
Lordship, whether we listen on 23rd of this month,
23rd.
Tuesday. I'm for the respondent number 1 and 2.
Third learned counsel for the petitioner, Mr. Medovero, who makes a mention on behalf of, who's on leave?
PP Paul, yes.
Mr. PP Paul, who's on leave, and prays that the matter may be listed on 23rd of September. So, learned additional AG, Mr. M. Timson, has no objections to the said prayer. So, yes.
Okay, much obliged, Lordship.
May I please, Your Lordship? I beg to mention hearing item number 13. The leading counsel is out of station, so kindly let the matter be listed after 2 weeks.
For 2 weeks, learned counsel, the message and such, who has submitted that the leading counsel, Mr. Sinti Younger, is out of station and accordingly prays for listing the matter after 2 weeks. So, learned government advocate, senior government advocate, Mr. K. Ngami is present, list after 2 weeks.
May I please, Lordship, if I may be allowed to mention orders item number 7. I may be allowed to file an IA for the new incumbent, Your Lordship. Respondent number 1 has been retired, Your Lordship.
Retired.
Yes, Your Lordship.
Learned counsel for the petitioner, Ms. R. Atsula Gibbs, makes a mention and submits that she may be allowed some time to file an implement petition as the respondent number 1 has retired from service. So prayer is allowed to list after 2 weeks.
Lordship.
After 2 weeks, yes.
Also, Your Lordship, item number 16 to 18, hearing item number 16 to 18. If this item can come up after 2 weeks.
Okay, what's the matter? Why do you want adjournment?
Your Lordship, the leading counsel here, he's indisposed.
Okay. Learned counsel for the petitioner, Mr. R. Atsula Gibbs, who has made a mention on behalf of the leading counsel, Mr. S. Waling.
Yes, Lordship.
S. Waling, who is indisposed. Stop. This is the matter after
3 weeks.
3 weeks. Stop. Learned government advocate, Mr. M. Longcomer is present. Yes.
Much obliged, my Lord.
Please, Your Lordship,
Yes.
I beg to mention item number 10.
Then,
Kindly grant us 3 weeks.
you are for?
Bit-
You are bidding for petitioner?
Yes, my lord.
3 weeks.
Yes, my lord.
For? 3 weeks to do what? This is a criminal petition.
Since I'm not the main counsel here, the main counsel instructed me to seek for 3 weeks, my lord.
Learned counsel, Mr. Such and such, who makes a mention on behalf of, who's the leading counsel?
Mohammed Shamin Utin.
On behalf of Mr. Muhammad Shamuddin, who is an outstation lawyer. Stop and prays for 3 weeks' time. So, learned PP, Mr. K. Angami has no objections. Place the matter after 3 weeks. Yes.
Much obliged.
For motion from the supplementary cost list, item number 24.
Mr. Luikam, this
Yes.
case is still around.
Yes. So my prayer is that let this matter be, the appeal matter, which is first appeal number 1 of 2017, which was transferred to Principal District Judge Kohima, be transferred back to Principal Court of Principal District Judge Dimapur. Since the parties counsel, they are facing a lot of inconvenience.
You also have no objection to this?
No objection, Lordship. I'm for respondent 1, 2, and 3.
Okay. This is an application under section 24 of the CPC. praying for transfer of first appeal number 1/2017 pending in the court of Principal District Judge Kohima, Nagaland, to the court of Principal District Judge Dimapur. Stop. Para. Heard learned counsel for the petitioner, Mr. N.K. Lutham, as well as the counsel for the respondents 1, 2, 3, Mr. Rainbow Zoom and Mr. M. Longcomer for respondents number 4 and 5. We'll transfer it. Stop. Para. The learned counsel for the petitioner has submitted that the instant matter relates to a land dispute between the petitioner village and the military establishment of respondent number 2 and 3 stationed at Rangapahar Army Cantonment. Stop. Para. On a number of occasions, the petitioner village, as well as the respondent number 2 and 3, had approached this court, praying for directions to the concerned deputy commissioner for settlement of the boundary dispute. Stop. By a common judgment and order dated 25/8/2006, this court in WPC 103 K of 2004 and WPC 72 K of 2005 had held that the dispute has not been settled in the nature of a proper civil suit by a court of competent jurisdiction, and accordingly this court had directed the parties to adjudicate the same in a court of competent jurisdiction. Stop. The petitioners thereafter filed a suit for declaration of right, title and interest and recovery of the suit land by impleading the Union of India as well as the state of Nagaland as the defendants in the Court of Civil Judge Senior Division, Dimapur, registered as Civil Suit 9 of 2007. Stop. In the said Civil Suit 9 of 2007, the parties appeared and the same was disposed of by a judgment and decree dated 12/1/2017. Stop. Being aggrieved by the judgment and decree dated 12/1/2017 passed by the Civil Judge Senior Division, Dimapur, the petitioners as appellants preferred the first appeal 1 of 2017 in the Court of Principal District Judge, Dimapur, Nagaland. Stop. Para. In the first appeal 1 of 2017, the respondents also entered appearance. However, the Principal District Judge could not take up the matter in view of the fact that the matter had been handled by her as a government advocate before this court. Accordingly, the appeal was endorsed to the Additional District and Sessions Judge, Dimapur, via order dated 6/8/2019. Stop. Thereafter, the Additional District and Sessions Judge was also transferred and posted to Woka. Thereafter, the appeal case was transferred back to the Court of Principal District and Sessions Judge, Dimapur, via order dated 11/11/2019. Stop. The said appeal was placed before the newly posted Principal District and Sessions Judge, Dimapur, on 27/10/2021. Stop. However, the said Principal District and Sessions Judge could not hear the matter as the judgment and order under appeal was passed by him. Therefore, the petitioner again filed an application before this court praying for transfer of the first appeal 1 of 2017 pending in the Court of Principal District Judge, Dimapur, to the Court of District Judge, Kohima, for further proceedings. Stop. This court, via order dated 5/12/2023, passed in TRP case number 2 of 2023, was pleased to transfer the said first appeal number 1 of 2017 to the Court of District Judge, Kohima. Stop. In Kohima, why do you find it difficult to appear?
Well,
Kohima and Dimapur is just.
the question is sometimes councils, they don't appear. So because of this reason, the matter has been prolonged. And even the council who was in the government panel, Dimapur, he resigned from the impanelment. So thereafter, government panel from Kohima was engaged. So there was some communication gap between.
The first appeal number 1 of 2017 has been transferred to the Court of Learned District Judge Kohima, but the same is still pending for hearing and disposal due to the difficulties of the councils who are all stationed in Dimapur. Stop. The petitioner therefore prays that for the convenience of the parties as well as their respective councils, the aforementioned first appeal number 1 of 2017 pending in the court of the District Judge Kohima may be transferred back to the court of Principal District Judge Dimapur for further proceedings and early disposal of the said appeal. Stop. The learned counsels for the respondents, Mr. Rainbow Isung and Mr. M. Longkamer, also have no objections to this said petition, as they are also of the view that the councils being stationed at Dimapur and also the parties to the appeal and has no objections to the present transfer petition. Stop. The previous transfer order was passed when? Next page.
That is at page 16.
16.
Yes. Starting from page 16.
You also want it in Dimapur?
Yes, yeah.
The parties are also, all of them are from the Burmese.
Considering the facts and circumstances as stated above, and on the submission, on the prayer of the learned counsels for the parties, this court is of the view that the first appeal number, what is that number?
1 of 2017.
Appeal number 1 of 2017, which is pending before the Principal District Judge Kohima, can be transferred to the Court of District Judge Dimapur, transferred back to the Court of District Judge Dimapur. Accordingly, this court directs the Principal District Judge Kohima to transmit the records of the first appeal 1 of 2017 forthwith upon receipt of the present order to the Court of the District Judge Dimapur, Nagaland. Stop. The parties shall thereafter appear before the Court of District Judge Dimapur on 24th.
It's all right.
24th, 25th, on
It will be on
25th September 2025. The registry shall transmit the records, the registry is directed to ensure that the Principal District Judge Kohima transmits the records of first appeal 1 of 2017 to the Court of the District Judge Dimapur, Nagaland, on or before 17th September 2025. With the above directions, the application stands disposed.
For motion, item number 25.
May I please, Your Lordship? Your Lordship, this matter pertains to the land dispute. Your Lordship, I'm for petitioner. Your Lordship, this matter pertains to the land dispute between the two villages, Your Lordship. That is the petitioners and the respondent number 2 authority. And this is the second time allegations that I'm filing before this honorable court, Your Lord. At the first instance, this matter has been tried before His Lordship which I've reflected in my next year one, Your Lordship. Page 24, Your Lordship. At the motion stage.
What happened?
Yes, Lordship. His Lordship had briefed my facts, and since this conferred to the Office of the Deputy Commissioners and it concerns to the appellate court jurisdictions, so instead of filing under applications to the 6 of the Constitutions of India, be converted to the Rule 32, Your Lordship, of the rules for the administrations of Nagaland and justice and police in Nagaland, Your Lordship. So,
you were advised to file a
yes, Your
revision.
Lordship. Yes, Your Lordship. In this matter, Your Lordship, I'm challenging the impugned judgment and order passed by the Office of the Deputy Commissioner Longling, Your Lordship.
Let's see the order, impugned order.
Yes, Your Lordship, Your Lordship will find it in my lecture 2A, 25, Your Lordship. And there is a lab copy on the following page, 25, Your Lordship.
25.
Yes, Your Lordship. And for Your Lordship, there is a lab copy on the following page. If I may, Your Lord.
Yes.
After hearing the submissions of the blend so-and-so, of the so-and-so represented by the German, the court found no substantive evidence to support the claim. Upon examining the agreement that is so-and-so entered into so-and-so by the so-and-so, it is noted that a fine of 50,000 was levied in connection with the unauthorized cutting of trees. The so-and-so is better. Terms of the agreement, the fine of so-and-so be deposited 21st October 1995, following which the plot of land at so-and-so would be forfeited in the favor of the Damlo Village Council. The evidence presented confirms that the said payment was not made by the so-and-so on the said date. It is considered view of the court that the incident case is primarily not a traditional land dispute between the two villages warranting customary taking. The land in question was forfeited in favor of the so-and-so as a result of so-and-so failing to pay the fine imposed in connection with the unauthorized cutting of trees with the stipulated timeline as per the terms of the agreement dated 14 October 1995. Therefore, the incident case does not qualify to be settled through customary taking. In view of the foregoing facts and after careful considerations of all evidence, the Court of the DC Longling upholds the judgments, orders of the DB's so-and-so dated 10 January 2025 and hereby pronounce the following judgment. The plot of so-and-so previously held by so-and-so is hereby declared in favor of the so-and-so, Your Lordship. Your Lordship, at the first instance, this matter has been tried before the office of the Tupashis Court that is in Damlo, which is a subdivision administrations of the Longling district. Your Lordship, while this matter was being tried to the concerned DP's court, the concerned office failed to observe to the merits of the cases, Your Lordship, and had simply relied to the agreement. What the respondent number 2 authority are claiming and accusing to the petitioner number 1 is, along with his father, that it was an agreement that has been executed, Your Lordship.
I don't understand what you're trying to say. Just come again.
Your Lordship, if I may be allowed to brief the facts.
Initially, the case was filed before the DB's court.
Yes, Your Lordship. First,
Yes,
it was being tried.
Yes, between you and
between me and the respondents.
the respondents.
Yes, Your Lordship.
Respondent
Respondent number 1 is landowners.
Respondent number.
Respondent number 1 is.
Respondent number 1.
Yes, Your Lordship. Is the landowner of the grandchild.
Okay.
And the respondent number 2 is the village council, Your Lordship. And the respondent number 3 is the concerned DB's court. Your Lordship, as long as it's concerned to this letter 14/10/1995, Your Lordship, if I may be allowed to brief the facts.
No, but how can you make the court a party? You are coming against the order of the DBs as well as the DC, isn't it?
Yes,
you're
Your Lordship.
You're impugning
Yes, Your
both.
Lordship. Yes, Your Lordship.
So now, you cannot impede the court as a party. It can be only respondent number 1. The dispute is between you and respondent number 1.
Respondent 1 and 2, Your Lordship. Yes, Your Lordship. The main party is respondent number 2, Your Lordship.
Respondent 1.
Respondent number 2, Your Lordship.
2.
Yes, Your Lordship.
Then
Because
in
they are
that
very much
case-
interested
in
to
that
this
case,
matter.
1
Your
and 2. It should be 1 and 2. Because 3 and 4 are the courts.
Yes, Your Lordship.
Respondent 3 is the court, 4 is also the court.
Yes, madam.
Yes.
Court cannot be implemented.
So you have to delete this 3 and 4. Okay. 1
Yes,
and 2, you can delete. Yes. Will issue notice.
Yes, Your Lordship.
The present revision is an application under Rule 32 of the Rules of Administration of Justice and Police in Nagaland, impugning the judgment order dated 1/7/2025 passed by the Deputy Commissioner Longleng, Nagaland, and the judgment order dated 10/1/2025 passed by the Dobashis Court, Tamlu, Longleng District, Nagaland. Case number, what about case number?
Your Lordship, all this matter was being tried in the office of the DC. There was no such case number. It was only an appeal, Your Lordship. However,
In the Dobashis Court, it was 3/25.
yes, Your Lordship, 3 of 25.
Against the judgment dated 10/1/25 in case number 3/2025, passed by the Dobashi Court, Tamlu, Longleng District. Stop. Para. Issue notice to the respondents number 1 and 2, returnable within 4 weeks. Stop. The counsel for the petitioner shall take steps for service on the respondents by registered post with AD, as well as usual process within 3 working days.
Your Lordship.
Stop.
Your Lordship, if notice could be issued through justice services, because for the registered post, I cannot trace it, Your Lordship.
No, you have to first try the usual process.
Yes,
Then after that, if it's not possible, then dusty. The petitioner is directed to delete,
3 and 4.
strike out the names of respondent 3 and 4, as they are the courts whose orders are being impugned in the present petition. So you strike off, okay?
Yes, Lord.
Yes, list after 4 weeks.
Obligement.
For admission, item number 1.
Yes.
Yes.
What is the last order?
As per the last order dated 29/7/2025, the respondents were directed to complete the process within 3 months. So 3 months is, and then the matter to be listed every month to get the update. Your Ladyship has passed the order, yes. 29/7/2025.
7. Submit the name of the petitioner. Yes.
Yes,
Have you
Your
done it?
Ladyship, this relates to regularization of a work
Yes,
charge
yes,
employee.
no.
And the particular petitioner is working as a night chokita in Fazaldi College, Mokshom. Now, the first step for regularization is the person must be verified by the district level verification board, which is normally headed by the deputy commissioner of the district. Now,
Yes, that was discussed on the last occasion
Yes,
also.
it was discussed
Right.
in
And then,
22/7.
he said that he was not included in the verification.
it was not included.
Due to some inadvertent mistakes. And therefore, the department had initiated the process again to
Yes.
submit the name of the petitioner. So what have you done after that?
Now we have initiated, but the district verification committee has to be set. They have to sit. It has not been set yet. And we have no authority over the things.
The
district level authority, district level verification committee, which is led by the deputy commissioner, must sit together and verify the antecedents of the petitioner. Now, this has not been said. Maybe we are expecting one of these states to sit.
You are respondent number?
One, that is the director.
Director.
And my friend is the respondent number 2. That is a principal of Azali College.
Have you made anyone from the government as contemner, the secretary?
No.
Then that is the problem. Because if it's a secretary, then they can give direction to the deputy commissioner to have the board. But as director, they cannot direct. But what about the writ petition? What about in the writ petition? Writ petition also, secretary was not a party.
No, my lord, in the writ petition, yes, the chief secretary. The chief secretary.
That is the problem.
Chief secretary
But
was.
in the contempt, you have not made chief
Yes.
secretary a party. Because as director and principal, they cannot direct the deputy commissioner to have the verification board. Unless you make the chief secretary also a party. Either chief secretary or secretary of education department. Now at this stage, what can we do?
In that case, I may be allowed to implead
Yes, you have to implead.
the chief secretary. Or
Otherwise, the respondents here, they have no power, they have no authority. They just have to wait for the deputy commissioner to, to constitute the board. Okay. Heard learned counsel for the petitioner, Mr. L. Nokuma, as well as learned counsel, Mr. Moa Yimchen, for the respondent number 1, and Mr. V. Zimomi for respondent number 2. So, Mr. Moa Yimchen submits that the petitioner's case will be included in the district verification. However, the deputy commissioner of the concerned district has to constitute the verification board, which has not been done by the deputy commissioner Mokokchung.
Yes.
By the deputy commissioner Mokokchung. So, therefore, the learned counsels for the respondents have prayed for some more time. So, at this stage, the learned counsel for the petitioner, Mr. L. Nongkamer, has prayed for some time to make necessary implementation of the chief secretary in the present petition. So there is a lot list after 2 weeks.
Item number 2.
Let me hear. Well, I am for the petitioner, my lord.
Yes.
G.N. Sayola, senior advocate, along with my lord D. Deka. My lord, this is a petition, my lord, for quashing of the first information which was registered as GD&T. My lord, it is a civil dispute, my lord, and it has been converted to a criminal matter, my lord. My lord, what happened, my lord, the petitioner purchased pulses for 3 occasions they have ordered. First time 15 lakhs, they have paid entire amount. Second time also 15 lakhs. They have,
Government?
okay. And third time, my lord, they have placed order for sending pulses for 9 lakhs, for which, my lord, they have advanced rupees 8 lakhs.
What about respondent 2?
They are not appearing. Once they have appeared, my lord, 18/6/24, subsequently they are not appearing. Because this is a civil dispute, my lord. On the face of it, if your lordship see at page 22, the first information. This is not a criminal matter at all. We have filed a my lord, suit in Jorhat. My lord.
Page 22? What is page 22?
Page 22, annexure 1. I am placing, my lord. I have honor to state that on 12 May, Director of Flour Mill Jorhat had purchased masoor dal and chana from the company amounting to 20 lakhs, so and so. in 8 lakhs in advance and kept 12 lakhs in credit. However, till that, the balance money has not been paid and they have stopped receiving my call and other supporting documents enclosed for ready refunds. So this is, my lord, they said that it was credit, but we have paid more, my lord, amount to them. But they have not supplied. That is why we have instituted a suit, my lord, a commercial suit in Jorhat.
Oh, you have instituted a suit.
Yes, my lord, we have instituted a suit, my lord, because preliminary notices have been issued, my lord, if you, I'm just touching, my lord, at page 29, my lord, if you also see first, my lord, that the mediation was there, and then mediation failed, and now we have, at that time, mediation was there.
Page 28.
29. For recovery of, my lord, rupees 14 lakhs and what, my lord, because they have not supplied the goods. This is pre-institutional mediation, my lord, under Commercial Courts Act, my lord.
Then what happened after this? After
Then the mediation failed and we filed the suit, my lord, suit is going on.
mediation failed.
And suit is going on, my lord. Because there is subsequent instance, my lord, because we filed at that time, my lord, this was there. So, my lord, on the face of it, my lord, it is a civil dispute, my lord.
You
My lord,
have not stated anything about the civil suit in this.
yes, we restricted, my lord, that is why we annexed it.
Para?
Yes, I'm just. My lord, the law supervisor. There are 14, my lord. Page 9. It is pertinent to state that having no alternative, the petitioner has prepared a commercial suit before a competent court at Jorhat claiming rupees 14,96,250 from number 2. The same commercial suit has been taken cognizance by the DSA Jorhat, Assam being pre-institution mediation number such I issued notice so and so to respond to, and he is repenting calling them to appear before the authorities for mediation.
No, but you're saying that the mediation failed, isn't it?
So the subsequent instance, my lord, because at that time, my lord, mediation was there. Now, my lord, the mediation failed and the suit.
No, it failed. So what is the civil suit number?
Just I got my lord about it. But on the face of it, my lord, if your lordships see page 20.
No, that also we'll see, but you have to.
Yes.
Check the fact.
My junior is giving, my lord.
You just give the civil suit number, okay?
Yes. And I'm, my lord, relying on the few judgments of the Supreme Court, my lord. Yes. In this regard, because this proceeding cannot be converted to the criminal, my lord, civil matters.
Yes, repeat.
Yes, I'm relying on the.
Yes. What else? What else?
My lord, I'm relying on the a few judgments of the Supreme Court, my lord, that civil dispute cannot be converted to a criminal matter for harassing the party, my lord.
That is not a dispute,
Yes.
but we have to go by the facts and circumstances of each case.
Oh, my lord, I'm sorry, my lord. The mediation, it is still mediation stage. Third notice has been sent. They are not responding.
But they are not appearing.
They are not. Third notice has come.
Yes.
Lordship,
On the
as
face
far
of it, it appears to be a civil dispute.
Lordship, in fact, I would like to submit an inquiry report also, which was submitted by the IA.
Okay.
Yeah, under section 41A, CRPC, Lordship, the petitioner was summoned, and thereafter, Lordship, under 161 CRPC, Lordship,
A
he was
statement was
examined,
reported.
Lordship. And Lordship, as far as inquiry report is concerned, the second page, Lordship, starting from the second page, I recorded the statement of Mahesh Beria, owner of Ramakrishna Flour Mill, Jorhat, Assam under Section 161 CRPC. On examination, the above noted person stated that his name is so-and-so and he started his own business in Gauhati, Assam. He also stated that he has received a police summons to appear so-and-so, and accordingly he appeared before the investigating agency and the said given date and the time, where he stated that he did not commit any crime against the complainant, Mr. Kivto Sema. Instead, he stated that he has paid all the amount that he was supposed to pay to Mr. Kivto Sema. This was his version to the allegation made against him. Mention be made that during the course, as no any concrete evidence could be established against him, he was thus released on PR bond, however, with the condition that he will appear before the investigating agency at any given date and time, as and when required by the investigating agency, Lordship. This is the inquiry report, Lordship. And the last paragraph also, it has been stated that it is to be noted that amid the course of inquiry, any order was passed. That is the observation, Lordship. So from the inquiry report.
Hello, my bank statement also I have enclosed, my lord, that 15 lakh, my lord, and 8 lakhs has been paid from the bank, my lord.
So from the inquiry report, it's clearly transpired that there is no concrete evidence. That is the
No, on the
inquiry
face of it also, it appears to be a sort of debt, civil nature.
So I leave it here.
Okay, we'll dispose. Heard, Learned Counsel, for the petitioner. Your name?
T.N. Sayola, Senior Advocate, along with T. Deka, my lord.
Sahibullah, Senior Advocate, assisted by
T. Deka.
B or
D for
assisted by Mr. T. Deka. Stop. Para. This petition under section 482 of the CRPC has been filed by the petitioner praying for quashing of the FIR dated 27/3/2023 registered at the suburban Dimapur police station as PS number GDE 8 of 2023 and the notices and the subsequent notices dated 31/3/2024, 23/2/2024 and 11/3/2024 issued under section 41A of the CRPC. Stop. Learned Counsel for the Senior Counsel for the petitioner submits that he is a businessman and the proprietor of one Radha Krishna flour mill situated at Gauhati, Assam. Stop. The respondent number 2 used to supply various kinds of pulses and had business relationship with the petitioner. Stop. The FIR dated, the impugned FIR dated 27/3/2023 is a result of an agreement for supply of certain quantity of pulses by the respondent number 2 to the petitioner on advance payment of rupees 8 lakhs. Stop. It is submitted that despite receiving the full payment from the petitioner, the respondent number 2 did not supply the agreed quantity of pulses, and when the petitioner started to demand the refund of the amount paid as advance, the respondent number 2 has filed the impugned FIR dated 27/3/2023 against the petitioner. Stop. Para. It is further submitted by the Learned Counsel that the respondent number 2 had failed to supply the pulses, though advance payment was made on 8/5/2020, i.e. at the time of placing the order. And when the petitioner had asked for refund of the advance amount paid, the respondent number 2 had requested for some more time to supply the same. Stop. The petitioner, thereafter, the respondent 2 had revised the rate of the pulses and requested the petitioner to make the full amount, to make payment of the full amount. Stop. the petitioner, acting on the promises of the respondent number 2, had paid another sum of rupees 1,50,000 to the respondent. Stop. However, the respondent continued to default in the delivery, and having no choice, the petitioner sought for refund of the advance amount. Stop. Thereafter, on making such demand, the respondent number 2, in order to avoid the payment, had filed the FIR on the impugned FIR on 27/3/2023 at the suburban police station, and the FIR has resulted in the registration of GDE number 8 of 2023. Stop. The submission of the learned senior counsel is that it is apparent on the face of the records that the respondent number 2 has filed the FIR dated 27/3/2023 only to dissuade the petitioner from recovering the due amounts arising out of the non-supply of the pulses as ordered on 8/5/2020, and there are no ingredients of any criminal act made out in the FIR, and therefore the FIR is nothing but an abuse of the process of law. Stop. The senior counsel for the petitioner has also submitted that in connection with the present matter, the petitioner has already preferred a commercial suit before a competent court at Gauhati, claiming an amount of rupees 14,96,250 from respondent number 2. So, the said commercial suit has been taken cognizance by the District Legal Service Authority, Gauhati, Assam, being pre-institution mediation case number 22 of 2024, and has issued a notice on 13/3/2024 to the respondent number 2, calling upon them to appear before the said authority on 18/4/2024 for mediation. Stop. However, the respondent number 2 has not appeared. Thereafter, several notices have already been issued to the respondent number 2, but till today, the respondent 2 has failed to appear for the mediation. Stop. The senior counsel therefore submits that the continuation of the instant criminal proceeding is an abuse of the process of law, inasmuch as the respondent number 2 can redress his grievances before the civil court for the alleged non-payment of bills. Stop. He further submits that if the investigation of such a matter, which is basically a civil dispute, is allowed to be investigated by the investigating agencies on the basis of the fabricated FIR, it would lead to miscarriage of justice. Learned Counsel has relied on the case of State of Haryana versus Bhajanlal, reported in 1992, Supply 1, SCC 335, in support of his contentions. The respondent number 2 has failed to appear before this court in spite of notice.
Once appeared, man.
Once appeared.
So 18/6, my lord, they appeared. 18/6/24.
18/6.
Yeah, after that.
18/6/24.
24. Yes. The order sheet, I think.
Okay.
Om Temjem. O Temjem appeared.
On 18/6/2024, the respondent number 2 had been represented by counsel and prayed for 3 weeks' time to to receive instructions from his client. However,
Subsequently, they failed.
subsequently, though the matter was listed on several dates after that, the counsel also failed to appear before this court. Only on that day, no, he appeared?
Yes, yes.
Learned PP, Mr. V. Rimomi, is present, and he has produced a copy of the inquiry report submitted by the investigating officer of the case. Where is that? That report is dated, the inquiry report dated 27/3/2023, submitted by the investigating officer of the case. So, in the report of the inquiry officer, it is stated that the statement of the complainant, not complainant, the statement of the complainant as well as the respondent / owner of Radha Krishna Flour Mill Jorhat were examined under 161 CRPC. Stop. During the course of the investigation, it is stated that no concrete evidence could be established against the the present petitioner, and therefore he was released on PR bond. Stop. As such, it is seen that during the preliminary inquiry, the investigating agency has also not been able to recover any evidence regarding any criminal act. Stop. Rara. This court has considered the submissions of the counsel of the petitioner as well as the learned BP, and has perused the pleadings produced before the court, pleadings on record. So it is seen that on bare perusal of the FIR, of the impugned FIR dated
27/3/24. 23. 27/3/23.
27/3/23.
27/3/23.
It is seen that the matter is relating to an amount of balance amount. In the FIR, he's demanding that 12 lakhs, isn't it?
Yes.
Is it with regard to a payment of rupees 12 lakhs, which the complainant has claimed to be the amount, to be the balance amount which has not been paid. Stop. And thereafter, in connection with the same matter, the petitioner has also resorted to filing a commercial suit which is under mediation as on date. Stop. This court is therefore of the view that the case is one where no criminal ingredient can be seen, and It is essentially and it is essentially of a civil dispute, stop, which can be adjudicated in a civil court. Stop. The respondent / complainant has also failed to appear before the mediator. Accordingly, the petition is allowed and the impugned FIR dated 7/3/23. Where is the first title? What about the notices?
Notices is now in fractures, my lord, nothing is there.
Sorry, fractures, I think, yes.
This can close.
Only the FIR now. Therefore, the FIR dated 27 or 7? I think it is
27, 3/23, my lord. You see that page 23, your lord will find, my lord. Oh, 7/3, sorry. 7/3, my lord. 7/3.
No, in your petition also you have stated 27/3. 27/3.
Oh, 27, my lord, yes. It is 27. Correct. 27.
27/3/2023. As well as the GD entry number 8 of 2023 is squashed and set aside. Petition stands dismissed.
Obliged. Item number 3.
May I please, Your Lordship?
Yes.
Your Lordship, I'm mentioning on behalf of Senior Yanawari for respondent number 1 to 4, Your Lordship. Yes, Your Lordship. My senior was been representing for the respondent number 1 to 4. However, Your Lordship, we have been informed that the respondent will be represented by the other councils. So, Your Lordship, I would like to withdraw my Vakalatnama.
Yes. Please, my lord, I have been recently engaged to represent all the respondents in this matter, my lord.
Oh, okay.
Respondent number 1 to 4.
Okay.
And I have been engaged by the department. The Chief Institute of Horticulture, that is under the Ministry of Agriculture and Farmers Welfare, my lord.
So you'll be filing
So
your...
today, for the first time, I'm appearing this matter. Do you have any submission? Yes. Okay. My lord, in this matter, my lord, affidavit in opposition has been filed on behalf of all the respondents. Now, this particular contempt proceeding has been arised from a common judgment and order dated 27/11/2024. My lord, I am not taking, my lord, to the detail of this judgment, but the simple direction was that in that particular judgment, that both the petitioner, that is petitioner number 1 is Arvind Singh and another one is Anjani Singh, both should be regularized in their present post. Thereafter, my lord, after passing of the judgment of the single judge, the matter has been dealt by the Ministry of Agriculture and Farmers Welfare. Thereafter, my lord, matter was referred to the Department of Personnel Training and Department of Expenditure. Now, here in this case, my lord, Department of Personnel Training is the nodal agency in respect of service matter for all central government employees. After dealing with this matter, both Department of Personnel Training and Department of Expenditure forwarded the matter to Department of Legal Affairs to seek their opinion. Then, my lord, may kindly come to para number 9 of my affidavit. Here, my lord, I have specifically mentioned that it was opined by the Department of Legal Affairs that the judgment that has been passed by the Honorable Single Judge dated 27/11/2024 need to be challenged. And in compliance with that particular opinion, my lord, two read appeal has been filed. My lord, that
already filed.
Yeah, my lord.
Writ appeals already filed.
Yes, my lord. Read appeal has been filed, but while preferring the read appeal, there is a delay of perhaps 190 days. So notice has been issued in the delay condonation petition, and yesterday both this appeal came up before this honorable court, quotum number 1, and I believe that they have entered their
remember item 9 and 10.
Yes. So my humble prayer before this honorable court is that, my lord, I'm not seeking a stay, but this contempt proceeding may be kept in abeyance until.
In any case, in a contempt proceeding, how can the court grant a stay?
No, no, I am not seeking a stay, that is why, my lord. I am simply making a prayer to keep further proceeding in abeyance, my lord. That can be definitely done. At least till next date, my lord. At least till next date, my lord. Because I would like to assure on behalf of the department, there would not be any delay on our part, my lord, while arguing this matter. As soon as the matter come up, at the usual process, we are ready to do the
Keep
hearing.
it pending then till the disposal of
Lordship,
the
I have no
writ appeal.
objection. Lordship.
Lord Learned Counsel for the petitioner, Mr.
I, Jamir.
Jamir. Stop. Learned Counsel, Mr. You are Mr.
Be the my lord.
Deka has entered appearance for respondents number 1, 2, 3, and 4. Stop. The respondents have also filed an affidavit in opposition, wherein it has been stated that a writ appeal has been filed. A writ appeal has been filed against the judgment of this court in WPC 38.
38 and 39, that's a common judgment and order.
WPC 38 and 39 of 2023. Stop. The notice has been issued in the said writ appeal on yesterday was 10th, on 10/9/2025, and accordingly Learned Counsel praised that this matter may be kept pending till the disposal of the writ appeal. Stop. Writ appeal number?
My lord,
13 of 2025.
12 of 25 and another one is 13 of 25.
Which has been registered as writ appeal number 13 of 25 and
12 and 13 of
12 and 13 of 2025. Stop. So we come to that to praise that the said matter, present matter may be kept pending till the disposal of the writ appeals. No? Writ appeals 12 and 13. Stop. Accordingly, this matter may be kept,
kept in abeyance.
listed after the disposal of the writ appeals 12 and 13 of 2025. Yes. Oh, you're also appearing? Oh, yes. Mr. Yangarwati submits that he has already withdrawn his Vakalatnama in respect of respondent number 1 to 4. Stop. And accordingly, his name may be struck off from the list of from the post list.
Obligation.
Item number 4.
Yes.
May I please, my lord, in the last occasion, I was directed to produce the CD, my lord. However, I am informed by the investigation officer that they have already submitted the final report. So my humble submission is, your lordship may kindly direct to produce the LCR, and the letter may be taken up on Thursday, coming Thursday.
Which court?
CGM.
Kohima?
Kohima, yes, ma'am. CGM Kohima.
Learned Counsel for the petitioner. Ms.
Weisbaum.
Such present. Stop. Learned PP Mr. Tipapum is present and has submitted that during the pendency of this petition, the charge sheet admits that the charge sheet has already been submitted in the present case, and accordingly he praised that the trial court records may be called for. Stop. List the matter when?
18/9.
On 18/9/2025. Stop. The registry shall call for the trial court records from the Court of Chief Judicial Magistrate, Kohima.
Your Lordship, there's an interim order.
The interim order passed earlier shall continue.
Your Lordship, here I am appearing for respondent 2 to 4, Your Lordship. Prior to respondent.
Learned Counsel, Mr. Sanitsach appears for respondent number 2 to 4.
Much obliged.
For admission from the supplementary course list, item number 27.
Yes. PP. Bail.
May I please, Lordship?
Call for medical report from the. Where's the PP? Who's appearing? Livika, who's appearing? Okay, call after some time.
Okay.
Yeah, call after some time. Bail.
May I please, Lordship? My Lord, here I'm yet to receive CD, my Lord. So kindly allow me 1 week time, my Lord.
Otherwise, I think the court has also called for the health, the medical report. And the medical report has come, but then the report is written by the superintendent of jail.
Yes.
Actually, it should come from the doctor.
My Lord, as per the order dated 4/9/2025, the Honorable Court has directed
No,
the superintendent of jail
That's why it
to furnish
says
the medical
also
report.
call for a medical report from the. No, it will be forwarded by the superintendent of jail, no doubt, but the doctor has to give the opinion, isn't it?
Yes, my Lord.
Yes, my Lord, I'm relying on the advice of the medical officer, which I have annexed on page 20. The petitioner was advised to go immediately for surgery, hemorrhagectomy.
No, we'll first have to see the case diary anyway.
My Lord, let the matter come up on Thursday, that 18th.
18th.
Yes, my Lord. 18/9.
On the prayer of the learned council.
My Lord,
learned PP, yes.
since on that 4, the case diary was called, and 18 is too long, since
my Lord,
the petitioner is suffering now. And
No, we may have to constitute a medical board also, because this will not do. Medical board has to be, because I think this is commercial quantity,
Yes, ma'am.
isn't it?
My Lord, though the order was passed,
22C.
my Lord,
NTPS.
though the order was passed on 4th, but I could able to obtain the CD only on that certified copy only on Monday. That is why I sent the.
You try on Tuesday?
Yes. So let them on 18, my Lord.
It's from here only, isn't it?
Yes.
From Kohima only.
15, my Lord.
16th, let it be
Fellows Article
16th.
21, my Lord.
Let it be 16th.
Okay, my Lord. Let's try.
Learned counsel for the petitioner, Mr. Pakin Chabos, the learned PP, Mr. Tipapong has prayed for listing the matter on 16th September in order to obtain the updated case diary. So, list on 16th September, yes.
Much obliged.
For admission, item number 28.
May I please, Your Lordship, there was a direction from this honorable court to let the accused as well as the person who has entered into a settlement to appear before the,
Okay, the complainant and her parents, the victim's parents, they have all given their statement and all disposed of it.
Okay, even if in that light.
Yes. The present petition has been filed under section 528 of the BNSS for quashing of the FIR and subsequent criminal proceedings against petitioner number 1 in Mokchung WPS case number 3/2024 under section 323/324 IPC, read with section 75 of the Juvenile Justice Act, corresponding to GR number 38/24, wherein a zero FIR was lodged by the petitioner number 2/victim's grandmother against petitioner number 1, alleging that the petitioner number 1 had physically assaulted the victim, who had been living with the petitioner number 1 at Mukupchung for the past 6 years. Stop. I've heard learned counsel, I've heard learned counsel for the petitioner. Mr. Your name?
Why Hunse, my lord? Why Hunse, my lord?
Okay. So such and Ms. Livika, learned BP for the state respondents. Stop. The submission of the learned counsel for the petitioner is that during the pendency of the criminal proceedings, the accused and the informant and the victim have entered into an agreement, thereby deciding to compromise the matter amongst themselves. The informant is the grandmother of the victim, who has been alleged to have suffered suffered beating at the hands of the accused while she was staying with the accused. Stop. On 22/8/2025, this court had directed the accused and the informant to appear before the court of the Judicial Magistrate First Class Bukchung within a period of 1 month, whereupon the JMFC Bukchung was directed to record their statements regarding the compromise deed and to submit a report to this court. Stop. Para. In compliance of this court's direction dated 22/8/2025, the learned judicial magistrate first class, the chief judicial magistrate Mokokchung has submitted the report, wherein it is stated that the court had recorded the statements of the accused and the informant, and the original compromise deed dated 28/4/2025 has also been furnished before the court, and the complainant in her deposition/statement deposed before the court that the victim's parents have forgiven the accused and does not wish to proceed with the trial and has no objection if the accused is acquitted. Stop. The statements of the accused and the informant have also been before the JMFC have also been produced by this court. The complainant in her statement has stated that both the complainant and her have reached at an amicable settlement, and she has forgiven the accused, and they have also entered into a compromise deed dated 28/4/2024. It is stated that the complainant is the grandmother of the victim, and she has categorically stated that the victim's parents as well as herself have forgiven the accused and they do not wish to proceed with the trial. Stop. In view of the above facts and circumstances, the present petition is allowed, and the impugned FIR dated 10/6/2024 and the subsequent criminal proceedings in GR 38 of 2024 corresponding to Mokokchung WPS case number 3 of 2024, as well as 3 of 2024, yes, 3 of 2024 is hereby quashed and set aside as as it will be a futile exercise to continue with the proceedings in view of the compromise deed executed between the parties. The petition
Obliged, my lord.
For orders, item number 6.
Yeah, please, Your Lordship. Lordship, I'm making a submission on the process, not on merit. Because, my Lord, issue has been created. So I would like to make a short submission on the process. Lordship, contempt petition was filed against the order dated 29/11/2022 passed in WPC 185 of 2019. The contemnors before this honorable court is taking a ground that the judgment was partially complied with, not fully complied.
Then Lordship partially complied.
Yes.
And therefore, the only 2 respondents being relevant.
Then thereafter, Lordship, yes. Thereafter, Lordship, the issue was taken up. Then respondent, Lordship, 10, 11, and 12 notice is yet to be effected. Notices are yet to be effected, Lordship. Then, Lordship, accordingly, Lordship, the matter came up on 20. Then the matter came up on 23/7/2025. And the matter came up on 23/7/2025, the counsel for the respondents 7 and 8 were insisting that the case should be heard without, though the notices are effected, yet to be effected upon the private respondents. Respondents number 10, 11, and 12. However, Lordship, on 23/7/2025, after hearing the parties by this honorable court, an order was passed that we were directed to take fresh steps upon 10, 11, 12 within 3 weeks' time. Accordingly,
Within 3 days.
within 3 days. Accordingly, we took steps. And Lordship, when the matter came up on 4/8/2025, last week, again, it was insisted by the counsel for the respondents 7 and 8 that the matter should be heard, though the notices are yet to be effected upon 10, 11, 12. That is the issue, Lordship. So my respectful submission, Lordship.
So you are saying that there is compliance.
We have already complied.
Already complied.
And Your
That is
Lordship,
the, Lordship, the issue is this. Let me complete and later submit. My only contention before, I'm not going on merit of the case today. Because, my Lord, I can go on to the merit of the case only when notices are complete. Only at that point, if this honorable court is of the view that notices will be dispensed with, then appropriate order may be passed.
Okay, let me see who are the newly impleted.
Lordship, if I may allow to speak, the direction of this court is only to the Deputy Commissioner Chumukedima and Dimapur. The direction was never given to the other respondents. In the first instance, also, the respondent is not supposed to
But
implead.
the court's order is already there.
Yes, that is the point.
No, but Your Lordship, it is only with regard to the contempt is between the court and the contemptor.
So
the court has to see whether there is a contempt or not. Accordingly, we have filed our affidavit. We have done the verification. If at all they are aggrieved, then can recourse
Who
to
are the
another.
new respondents?
My Lord, the respondent number 10, the secretary, the secretary, engineer-in-chief, and the chief engineer national highway. What the only thing, Lordship,
So if they were not a party in the writ petition,
my Lord,
then how
my
can
Lord,
they come?
upon the retirement of the incumbent, they were substituted.
Even if they impleaded them as a party respondent, this court has the jurisdiction to strike off because
My
the
Lord-
direction is only to the Deputy Commissioner Dimapur and Chumukedima, Lordship.
My Lord, the only
Because
issue
it's a contempt.
My Lord, the only
It
issue
is not a writ petition.
I'm not on the merit. My only issue is this. My Lord, it's under process. I'm not giving any comments on the merit because it is premature for me to go into the merit now. Rightly or wrongly, Lordship, on 23/7/2025.
The direction may come to Lordship.
Lordship,
They have
regardless of
not-
the order on 23/7/2025.
They have not even paginated the page, but if you come to the Lordship, paragraph 34 of the court order, Lordship.
Lordship may kindly allow me, if your Lordship
No,
desire to see.
that I've seen, 23-7.
Yes.
The direction for fresh steps. is
Yes.
there.
So only there,
But I
Lordship.
just want to see the direction.
Lordship,
Yes,
from
the
91, page 92, Lordship, page 92. Page 92 and 93, Lordship. If you, Lordship, allow me, I will read.
Yes, 92.
This court declares that the action of the Deputy Commissioner to enlarge the width of the road reserve to 27 meters from the center in the stretch from such and such highway from Dimapur to Kohima without carrying out any acquisition, and more particularly a notification dated consequently stand vitiated for not following the due process. The landowners whose land falls within 13.5 meters from the center of the road on the stretch of the road, if affected, would be entitled to compensation. Taking into account that this court is not in a position to decide how much and which land of each of the petitioner or any of the landowners have been affected, it would require a fact-finding inquiry. The court directs the petitioners to submit their claims, including their claims for destruction of their properties, along with their land documents and other documents to Deputy Commissioner Dimapur, Chumukutima, before whose jurisdiction their land falls within 45 days from the date of instant order. Taking into account that only 230 petitioners have filed a standard petition and there may be other landowners who have been affected, this court further directs the Deputy Commissioner Dimapur and Chumukutima to issue notices in daily wise regulation for claims along with their documents for verification. 3. On the basis of the claims, as well as documents who submitted Deputy Commissioner Dimapur Chumukutima or any other person the whom the Deputy Commissioner deemed fit to entrust, but not below the rank of ADC, shall verify the said claims on the basis of the documents submitted within the period of 6 months from the date of submission of the claims. In filing the said claims, the petitioners as well as the landowners would be at liberty to submit their claims regarding their loss suffered on account of demolition of their properties. Upon the verification, if it is found that petitioners or landowners have been affected on account of enlarging of the width of the highway from Dimapur to Chumukutima, in that case, the Deputy Commissioner Dimapur and Chumukutima, in consultation with the state, my lord, here direction is to the state also. 4. In consultation with the state of Nagaland as well as respondent number 2, shall initiate proceedings. If it is made clear, if in the circumstances the petitioners and the landowners are aggrieved by the fact-finding inquiry, liberty to initiate proceedings under CPC. If the petitioners, however, agree by the actions of the respondent authorities in respect of entitlement of quantum of the compensation, avail the remedies available under the National Highway Act. So the direction is not only the state, and not only the deputy commissioners, but for the state to act also. That is the directives.
Only after the verification report, if we found that we have encroached the land of the petitioner, then only we can acquire their land. But when we gone through the verification, Lordship, only 6 petitioners are entitled for compensation only. Because the question of acquisition does not arise, because most of the petitioners, they are in excess occupation of the land, Lordship.
Okay. So only Deputy
Commissioner Dimapur and Deputy Commissioner Chumukutima
were supposed to conduct the verification.
We have conducted the verification. We have filed our affidavit since long time back. Now, if at all they are aggrieved with that one, they have to approach the civil court, or they can take another alternative remedy, but not by way of a contempt, Lordship.
And only if it is found that their land has been encroached,
yes,
then it shall be the proceeding for acquisition
yes,
will be initiated.
yes,
That
yes,
is the direction.
yes.
My lord, the issue is this.
So if they have already conducted the
My
fact-finding
lord,
inquiry,
the issue is this.
and if it is
Yes,
found,
there is no direction.
then what remains?
My lord, the point is this. I'm not opening my mouth today on the merit. Because once the merit starts, I'll show from the report.
We only have to see. It's very limited.
My lord, the question is this.
jurisdiction.
The question is this. Initially, I am open for
You
submission.
may have to file a new
My lord,
petition.
I am open for submission, but the point is this. There is an order by this honorable court. I'm only making a pointed
We are
submission.
only prolonging the.
Yes,
So, my lord,
exactly.
if that is so, then order is passed, then we can fix a date for admission hearing, and you,
No, today
Lordship
itself
pass an
also.
order to dispense the order.
Because,
No,
Lordship,
because, my lord, the order is, today the matter is listed for order.
whatever
So,
be,
Lordship,
whether
you
there is
pass
a
an order,
contempt or not, the court has to
pass an
say.
order that the notice upon the respondent is dispensed with, and then we can fix a date immediately for admission.
Today also we
no
can
problem,
dispose.
Lordship, but then the process has to be followed.
No.
Let the process be followed.
He wants the
Lordship.
process to be followed in his case,
My
and
Lord,
he wants
no,
the contempt to be
because-
pending.
because the court's
That is
orders-
an abuse of the process of this
Since
court, Lordship.
This court's order 23-7 is there,
Yes.
we will say that 10, 11 and 12 are not necessary party.
Even the other, only Lordship, only Deputy Commissioner Dimapur and
No,
Chimukadima
my
are
lord,
the
others
necessary
will be
party.
required because there is a direction upon the state government.
No,
That is
that's
the
not.
second step. That is the second step.
My
Only
lord,
when
because
it is
you see-
found
you
that
see
Yes.
the
your
question-
land
no,
is
no.
encroached, then the state
Lordship,
will
the
come
point
in.
is this.
Yes.
The point is this.
Yes.
He is giving a submission. She is conceding to the point that few people are eligible in terms of the finding.
Yes.
But after that, no action has been done by the thereafter.
We have
For them
forwarded
also,
to, we have
no.
forwarded to the government.
So that
And the-
issue will be there. That is
No, no. In a contempt, that cannot be determined. Lordship, the contempt, we have to see what is the direction of this court. And we have complied with the court. If at all the petitioner is aggrieved, that would amount to a new course of action, not by way
No,
of a
but in
contempt.
respect of those 6 people.
Yes.
Yes, we have already
They have to be
forwarded.
paid. They have
Yes,
Yes, they have to
nothing
be
has been
paid.
done.
We have forwarded to the
Nothing has been done
government.
because-
The court has not directed us
No,
to
my
pay
lord,
the money within that
Deputy
period.
Commissioner has
that
to walk.
period time has not been given.
Not
The
given.
the
So we
Deputy
have
Commissioner
given
has
some.
to act.
No, how can,
Yes,
it
under
is
the
a
Highway
contempt,
Act.
it is a
Under the Highway
contempt.
Act. Read the-
Then the petitioners.
If at all they are
petitioners
aggrieved, they have to take a new course of
proceed to
action.
initiate Proceedings. If the petitioners are aggrieved by the quantum, then they can avail the remedies under the National Highways Act. What is the stage now, their payment?
Our Lordship, we have forwarded to the government for payment. Only
No,
the
my
6
My lord,
petitioners.
Lordship, kindly read the judgment properly.
I don't think
I
there is.
There is no
it not
contempt.
the forwarding only,
On
but
that
they have,
matter, I may
he
be-
sees the authority under the Highway Act to pay. It is not the government.
Lordship, I may be allowed to read one Supreme Court judgment, that is 2004
What, Lordship?
ACC
We'll do one
400.
thing. We will say that the respondent 10, 11 and 12 may be struck off, and then we will keep it for, we will hear on the next day.
No, Your Lordship, today itself, because the Lordship,
We have to follow
when
the
there is a
No, the
contempt,
problem is, I understand what you're trying to say, but the problem is this 23-7 order. So
It was
we-
passed in
we-
her presence,
we
Lordship.
have to overcome this.
no, but whatever, even this Lordship has
So-
the
so I
ample
have-
power
I
to,
have to say something on this, that is the only thing.
whether the filing of the contempt
week,
is an
next week.
abuse.
No
or-
problem.
Next week, Lordship, it will be difficult for me, Lordship. Otherwise, keeping pending the
22nd,
contempt.
22nd.
22nd.
You see, Lordship, I'm not in here not to hear the matter, but process has to be followed. That is
No.
what I'm submitting only.
No, when they are not a
This has to be
necessary party,
disposed.
process is not required, Lordship.
Closed. 22nd.
Lordship.
Mr. Takamasa, Learned Senior Counsel, assisted by Mr. Sentilong, present for the petitioners. Stop. Learned Counsel, V. Shukri is present for the respondents number. You are for?
Lordship, I am for respondent to the number 329.
Respondents number 329. Stop. By order dated 23/7/2025, this court had directed the petitioners to take first steps for notice of service upon the respondents number 10, 11, and 12 within 3 days by registered post with AD as well as usual process. Stop. Upon going through the judgment of this court dated 29/11/2022, this court has seen that the direction was given to the Deputy Commissioner Dimapur and for conducting a verification. Verification or fact-finding, or for conducting a fact-finding inquiry. So, and thereafter, if it is found that the land of the petitioners / landowners were destroyed or encroached, then the Deputy Commissioner Dimapur and the Deputy Commissioner Chimukadima had to initiate the proceeding for acquisition in consultation with the state of Nagaland, as well as the respondent number 2. Stop. Therefore, this court is of the view that the respondent number 10, 11, and 12 are not necessary parties in this contempt petition, and accordingly they are struck off from the list of respondents in the cause title. Stop. This is the matter for admission on 22nd
Lordship.
September. Yes.
Otherwise, Lordship, even the respondent number 1 to 6 also need to be struck off
Well, Lord,
because they are
let it
unnecessary.
let it
parties.
remain.
Let it remain.
Also,
Let it
Lordship,
remain.
Lordship. Much obliged.
Okay, we'll just come back 5 minutes.
For orders, item number 8.
May I please, my lord? Lordship, I have instruction to appear for respondent number 1 in this case, Lordship. I am appearing for the first time.
Respondent 1.
1, my lord.
And where is the petitioner? And
I have the instructions to
You are
appear
for?
for respondent number 3. I will be filing my Banglat number in the course of the day for respondent number 3.
Learned counsel for the petitioner, Mrs. Jimbomi is present.
Yes,
So,
Lordship.
Mr. N. Angami
Yes.
enters appearance for the respondent number 1.
1.
Stop. Mr. N. Longkamar has also entered appearance for respondent number 3. And Mr. Im Tim Song enters appearance for respondent number 2. You have all filed your power?
Yet to file.
Not yet. Not yet. Okay. How much time? 3 weeks?
Yes.
Because you have to file affidavit also.
Yes, receive instruction.
Stop. Learned councils have prayed for 3 weeks' time to file their power and also to file and also to receive instructions and to file the affidavit in opposition. Stop. Accordingly, list the matter after 3 weeks.
Lordship, just for the consumption of the Honorable Court, those in COB 16, because I have not yet received the COB 17, I have not received any copy.
This is for 16
16,
only.
yeah, 16, all the petitioners, 1 to 8, they are respondent in the appeal, in the principal bench. So this is for consumption of the Honorable Court, that we do not know what will be the outcome of
But
the.
you have to produce some order.
Yeah, I have.
Valid appeal.
Just actually here,
Admitted.
delay canton, but I have not yet updated. Then another matter, the condemnation hearing is not yet done. That will be come up in the first week of October in the principal bench. But in this matter, all those pertaining the 16 of COB 16, delay was canton. But I need to update what the status of the appeal.
No, if delay is condoned, then obviously it is admitted.
Yes.
In the principal bench. Yes, Lordship, but on the other hand, pending the writ appeal in the principal bench does not have any liability on this because there is no stay. That is the aspect.
Yeah, there is a difference here. Appeal was not done by the state. Appeal was done by the aggrieved party in the petition. Now, we are going to implement the direction of the Honorable Court.
Yes.
So if the appellate court again come to a conclusion, then that with a different finding, then again we'll be in the trouble. Otherwise, we have already started the steps. But the thing is, what will be the outcome of the appeal? So that is for the consumption of the Honorable Court. No.
There is no stay.
Judge order.
Yes.
No, stay may not be there since we are not the appellant. But even if there is no stay, the outcome of the appellate court will be, it affects the whole thing.
Let's not mention this for now.
Yes.
But
It will have no bearing whether Supreme Court or.
It is not our ground. It is knowingly it is not our ground. That is only for the consumption of the Honorable Court.
Just a simple submission before this Honorable Court is the 6 months after expiry, Lordship knows that another 4 months was granted, and their ground is we are under preparation for advertisement. So basing upon that only, strictly on that only, 4 months was granted. Now that 4 months has already expired on 20th July. Now what excuse will they bring before the Honorable Court? That is my humble submission.
Let them fight.
Yes.
I have never seen so much excuses in my life.
Item number 9.
Similar prayer, madam.
Lordship, here I have not.
Same respondents.
Same
Yes,
respondent.
I have not received any copy. My copy. 17. I received only the 16.
Is it?
Yes, 17. No, I have not received.
No, it's okay. It's okay. I will just same order.
But just say that the counsel for the petitioner shall serve a copy of the petition on Mr. Im Tim Song, General Counsel, for the respondent number.
By tomorrow.
Respondent number 2 by
Tomorrow,
by tomorrow.
Lordship. Obliged, Lordship.
Item number 11.
Condonation.
Yes, sir. Lordship.
Any objections you are filing?
Yes, Lordship. I will be filing. Respondent number 4 and 5 are still awaited, Your Lordship.
Still awaited, no?
Yes.
Learned counsel for the appellant, Mr. Medo Vero is present. Stop. Learned counsel, Mr.
No, on behalf of respondent 1, 2, and 3.
Respondent number 1, 2, and 3. And praise for how much time? To file your
Lordship,
application.
after the vacation. After the vacation.
So vacation. Praise for listing the matter after the puja vacation in order to file his objections. Stop. In the meantime, await service report on respondent number 4 and 5. List after the puja vacations. Yes.
Much obliged, Lordship.
Item number 12.
If I may, Your Lordship.
Yes.
My Lord, during the pendency of this contempt petition, respondent number 3, the then Home Commissioner, Anup Kinshi, has been transferred. The present incumbent, Sri Abhijit Sinha IAS, is in charge. And therefore, I pray that he may kindly be implemented as respondent number 4.
Now, Journal Counsel for the petitioner, Mr. Your name?
Akam Iyer.
Akam Iyer. Stop. This is an application under Order 1, Rule 10 of the CPC, bringing for implement of Mr. Abhijit Sinha as respondent number. He will be
Respondent number 4.
As respondent number 4 in the connected COP number 3 of 2025. Stop. It is a submission of the learned counsel for the petitioner that the COP number 3 of 25 had been filed before this court for willful and deliberate disobedience of this court's order dated 14/11/2024 in WPC 133 of 2022. Stop. Para. During the pendency of the said COP 3 of 2025, the respondent number 3, who was the Home Commissioner, has been transferred in the month of August 2025, and Mr. Abhijit Sinha IAS has taken over as the new Home Commissioner, Nagaland. Stop. And therefore, the petitioner prays that Mr. Abhijit Sinha IAS may be implemented, Home Commissioner may be implemented as respondent number 4 in the connected COP number 3 of 2025. Stop. Considering the prayer of the petitioner, this petition application is allowed, so the petitioner shall take steps for filing an amended cost title, impleting the name of Sri Abhijit Sinha IAS, Home Commissioner, as respondent number 4 in the COP 3 of 2025. So, Learned Counsel, Mr. N. Nongkamar is present for respondent number 2, and Mr. Tiba
Respondent number 1.
for respondent number 1. Put up after, you can do it within a week's time, just after 1 week.
For hearing, item number 21.
What the Jamir?
Mr. Lordship,
Yes.
both the parties present, how?
You're ready? You're ready to take up?
Yes, the parties are ready.
Just bring one more. The small one, nah? It's almost
I'm sure, Lordship.
yes. Pension.
Lordship, familiar pension. Lordship, before I refer to the annexures, in the pleadings, Lordship.
Who is appearing for the respondents?
CGC.
You'll appear.
Yes, Your Lordship. My senior will be present.
Oh, he'll appear. Young Wati.
Yeah, he's here.
Okay.
Lordship, the petitioner is the wife of deceased Assam Rifle, who died in harness while serving in the Assam Rifles. After the death of my husband, Lordship, I've submitted a representation for pension, family pension. However, Lordship, the respondent, Assam Rifle, failed to consider my representation. Therefore, I approached this honorable court by filing a writ petition, which was numbered as WBC 164 of 2022. Now, in that case, Lordship, 164, I think next, I'll refer to that later, Lordship. So, by filing affidavit of opposition in that writ petition, a letter was enclosed by the Assam Rifle, stating that my prayer has been considered. And in that letter, Lordship, it is stated that my husband has already been discharged from service. Therefore, the petitioner herein is not entitled for the family pension. So that was the ground taken in that petition. Therefore, in view of consideration of my representation, because my prayer was to dispose of my representation in that petition, the petitioner withdrew that petition. And in the present petition, the petitioner is challenging the discharge of the petitioner's husband. Lordship.
Oh, that means their ground is that before he passed away, he was already discharged.
Yes, that is their ground. However, the petitioner never knew about the discharge of her husband. And before the petitioner husband dead also, he was not aware about the discharge from service, Lordship. So, Lordship, I may take your Lordship attention to some of my paragraphs in the writ petition. In order to save time, Lordship, I am reading few paragraphs. Lordship, I am reading from paragraph 2. That the Jagisang tribe of Nagaland, to which the petitioner belongs, is one of the backward tribes under the state of Nagaland. The petitioner is also an uneducated widow hails from a remote interior village from backward tribe. That the petitioner's late husband was enrolled in Assam Rifle on 29/11/2003 and posted to then Assam Rifle after completion of basic training. Paragraph 4. That while the petitioner's deceased husband was posted as Sir Chief at Mizoram, he was declared mentally unstable from the Battalion Mental Hospital in the month of August 2015, and since then, he was under medical treatment till he breathed his last on 14/5/2019. Consequent upon the detection of his mental condition, he was referred to Sukhoi Assam Rifle Hospital, Dimapur, Nagaland for intensive treatment, and he was treated in the said hospital with effect from 13/8/2015 to 17/2/2018. I have annexed the medical certificate also, Lordship. Paragraph 5. That the petitioner begged to state that her late husband went missing while returning back to his posting place from railway station Haflong, Assam on 19/9/2018 due to his unstable mental condition. A missing report was filed white FIR number so dated 29/2018 before the concerned police station. However, the FIR was withdrawn on 22/9/18 after relocating him on 21/9/18 at Dimapur railway station. Paragraph 6. That the petitioner begged to state that in view of the petitioner's deceased husband mental instability, the authority granted leave with effect from 13/11/2018 to 31/12/2018. On expiry of the leave period, when the deceased husband reported to Battalion on 13/1/2019, his leave period has been further extended for another month from
16/1/2019 to 14/2019. Paragraph 7. That the petitioner begs to state that when her deceased husband came back home from the place of posting in view of subsequent extension of leave, the petitioner was informed that he was made to sign certain documents for voluntary retirement by the officers in the Padaland. The petitioner, sensing some foul play by authorities taking advantage of his mental disability, she immediately submitted a representation dated 18/1/2019 on behalf of her husband to the Commandant then Assam Rifle, bring forgiveness to her husband and requested to revoke his application form for availing voluntary retirement. Another representation dated 25/1/2019 was also submitted, bring for to cancel, revoke the voluntary retirement process that may have been initiated with his signature in the form. Paragraph 8. That the petitioner begs to state that when her deceased husband was still in the his leave period, one so-and-so, a fellow Assam Rifle, on 31/1/2019, personally came to the place of petitioner in Kohima, Nagaland, and handed over a set of forms containing a format of pre-receipt from so undertaken format for drawal of advance or withdrawal, option from B so-and-so for receiving payment through electronic mode, Form A for claiming so-and-so, Form C for so-and-so, nomination papers stating that her husband was discharged from active service. However, no formal discharge order has been served to the petitioner on her deceased husband. But well, the representation submitted by the petitioner for cancellation and revocation of the application form for availing voluntary retirement and the process thereof was pending before the authorities. Her husband unfortunately passed away on 14/5/2018. After the death of the petitioner late husband, the competent authority issued succession certificate dated 6/3/2020 in favor of the petitioner. Till that time, the petitioner was not aware of the discharge of the petitioner husband from the service. Paragraph 10. That after the death of her late husband, the petitioner submitted a representation dated so-and-so to the Commandant then Assam Rifle, bring for grant of family pension and other service benefits of her late husband. Paragraph 11. That however, by intimation letter dated so-and-so and by another order so-and-so respectively, the petitioner was indemnified regarding final payment of GVF and payment of so-and-so dues to her deceased husband. Paragraph 12, Lordship. That the petitioner late husband was the sole breadwinner in the family consisting of 2 minor children, and in view of his untimely demise, there is no source of their livelihood as such. The petitioner again submitted a representation dated so-and-so and the form of a mercy petition on 8/4/2021. Though the respondent number 2 bring for grant of family pension to her husband, to her for the service of her deceased husband. However, despite lapse of time, the authorities turned a deaf ear to her grievance as such. The present petitioner approached the Honorable Court by filing a writ petition, which was registered and numbered as WBC number 164K of 2022, with a limited prayer before this court to direct the respondents to dispose of her representation. Next paragraph, Lordship. That the respondent authorities, the Union of India, by filing affidavit in opposition, place on record the imbued order dated 8/5/2023, by which it is being informed that the discharge of her late husband's service was approved by competent authority with effect from 31/1/2019 by Director General of Assam Rifle letter dated 15 January 2019, and since the petitioner late husband did not approach any of his severe authority for withdrawal of his application for premature discharge, his discharge from service attained finality on 31/1/2019. By the said ambient letter, it is also informed to the petitioner that family pension and other retirement benefits cannot be granted.
In view of the subsequent development during the pendency of the writ petition, whereby the application submitted by the petitioner had been disposed of by the ambient order dated so and so, this honorable court, by order dated so and so, was placed to go close and dispose of. Paragraph 15, I'm skimming paragraph 14, Lordship. Paragraph 15. That the respondent authorities, by filing affidavit in opposition in WPC number 164 Kia 2022, based on regard that the petitioner late husband submitted an application for discharge from service at his own request and also signed in the undertaking form for resignation from service. There is no dispute that the petitioner late husband was mentally unstable. It is stated that when her late husband returned home from place of posting in the month of January 2019, had informed the petitioner that he was made to sign some form of waivers for voluntary retirement. It is beyond human imagination that a prudent man, after serving for more than 15 years, opted for resignation without any service retirement benefit. Therefore, the petitioner has reason to believe that her late husband was made to sign an application form for discharge as well as taking advantage of his mental disorder. The respondent authorities ought to have granted invalid mention under the relevant provision of law if the petitioner at that point of time was not fit for service instead of resorting to such unethical action towards a uniform personnel. Therefore, the action of the authorities is totally arbitrary and illegal. It is stated herein that the said documents allegedly signed by the petitioner late husband were available only through the affidavit filed in the said writ petition. This surprising fact reveals that the said documents is that the alleged signature of the petitioner late husband does not tally, as such respondent authorities may be brought to strict proof of such action. Lordship, what happened? By filing affidavit in opposition, two important documents has been brought and recorded by the respondents. The application allegedly submitted by the petitioner husband. That is on 6/11/2018. And the undertaking of the petitioner late husband. That is on 16/11/2019. Those documents happened to be executed when the petitioner husband was on leave at home. Therefore, Lordship, we can come to the annexures.
Annexure is...
Before that, I'm referring to annexure A, page 18. This is the service number of the petitioner husband. Service certificate, Lordship. Second, next page is the type copy. Third, also similar documents to show that he is a rifleman under Assam Rifle. Page 22, Lordship. It's a health card certificate issued by the Assam Rifle in respect of the petitioner husband. Lordship, may kindly come to page 23. This is the particulars of the petitioner husband. And page 24. He treated at this hospital from number 1, Lordship, 13/8/15. And Lordship, may kindly come to last column, Lordship, serial number 5, till 17/2/2018. As I have stated, my husband was mentally disabled, Lordship. And page 25 is the missing report of my husband. Married, Lordship. This is also important in order to show that my husband was suffering from mental disorder. To the officer, South Police Station, Kohima, so missing report. I have the honor to state that my husband, named so Village so Upper Agri Colony, working at then Assam Rifle and presently posted in Serchhip District, Mizoram, has been found missing. He was home on leave for the last 38 days and left on 19 September 2018 at around 6 a.m. for Serchhip, Mizoram by train from Lamding, Assam to join his duty, and was supposed to reach his place of posting same day, that is 19 September by so. However, lost his conduct, and when contacted his friend at Serchhip, Mizoram, found that he did not reach his posting place till day. He was last conduct at Haflong, Assam. His conduct number is so. Therefore, request your country to kindly look into the matter. This is the FIR missing report filed before the police. And page 26 is the withdrawal of missing report because her husband was relocated on 21/9/2018 at Dimapur. So by this, the missing report was withdrawn. Now page 27. This document is, Lordship, relevant because here the signature of my late husband is appended, Lordship. And this is certificate. This is Office of the Assam Rifle, so. Lordship, I'm reading paragraph 2.
Where is the signature?
Right down below, Lordship. Below photo, Lordship.
Oh, okay.
So this paragraph 2 is also important, Lordship. This certificate is valid till 31st December 2018. Its details are as follows. And this was issued on the left side, Lordship. 13/11/2018. Before I refer to the next documents, Lordship, may kindly come to affidavit and opposition of respondents, Lordship. Page 18.
Yes. Request
This
for
is the alleged application submitted by the petitioner husband. Request for resignation, discharge from service at own request. May I read, Lordship?
Yes.
With due respect and humble submission, I beg to lay down the following few lines for your kind consideration and sympathetic order, please. Thus, sir, I have joined in Assam Rifle on 29 November 2003, and I have completed 14 years, 11 months of qualifying service on 9 November 2018. Lordship, this application was 6 November 18. However, it is stated in this application that completed qualifying length of service on 9 November 18. There is a discrepancy. Due to prevailing domestic problem at home, I am unable to render further service. I further undertake certify that it has been explained me that no personal benefit will be admissible. No pensionary benefit will be admissible to me, and that I will not change my mind and seek cancellation of my discharge at own request once discharge date is fixed by so. Lordship, may kindly come here the signature at page 27 of the writ petition and page 18 of the affidavit of session. Totally different. And again, on the affidavit of session, we'll come to page 31. This is the documents produced by the respondent. Same application, different format on the same date. I don't understand
This
why,
one also,
how.
this one is also for discharge.
Yes, how these things happened.
Same day, 6 November.
Same day, same application, but the format is different. Signature also thoughtful, because signature doesn't tally with annexure F, page 27 of my writ petition. Totally different, even by the naked eyes, Lordship.
In fact, even annexure, even page 18 and 31, the signature is different.
Lordship. That is why I had a specific statement, it is a manufactured documents.
15 years. 15 years.
Now, Lordship,
Then,
while holding the affidavit of association, I can, Lordship, may kindly come to my writ petition, page 29. This is the leave granted to the petitioner, Lordship. Lordship, only, Lordship, it is written by Hindi, but the leave was granted with effect from 16/1/2019, 16/1/2019 to 14/2/19.
14.
This is the leave granted to the petitioner late husband.
Yes.
Lordship, may kindly come to page 19 of the affidavit of association. Okay.
Page 19.
Thank you. This is a document allegedly signed by the petitioner late husband, undertaking certificate. Undertaking certificate certified that I will not change my mind and seek cancellation of my discharge at all request once discharge date is fixed by so. Lordship, this was issued, undertaking was executed on 16 November 2018. And again, Lordship, may kindly come to page 27 of the writ petition. 27. My leave was granted from 13 November 2018. So when I was at home, this undertaking was executed as per the documents. Has Lordship got it?
The undertaking certificate.
Yes, I was at home. Because my leave period was from 13 November 18. Page 27 of my writ petition. Valid till 31st December.
Page 27.
7.
No, 29, I think. Page 29.
29 is, yes, that is also relevant, but then
Leave
this,
granting.
page 19 of the affidavit of association, Lordship, this undertaking was executed on 16 November 18, Lordship. Has Lordship got it?
Yes. 16th.
I've granted leave from 13 November 18,
Where is that?
page 27, down below, left hand side, 13 November 2018.
13 November 2018.
So on 16 November, I was on leave.
This is to certify that such and such proceeding on leave. So valid till 31st
Yes,
December 2018.
from 13 to 31st December. And this undertaking, allegedly executed by the petitioner, husband was on 16 when he was on leave. That is what I want to appraise this honorable court. And the signature also, Lordship. Lordship may kindly come here. Whether the signature is same. And another undertaking, page 20 of the affidavit of association, Lordship. Has Lordship got it?
Yes.
Same date, 16th November 18th. This was also allegedly executed when I was in leave at home with my family. And the signature is also different signature, Lordship. Now, Lordship, may kindly come to page 30 of my petition. This is a representation submitted by the petitioner after she was informed by her husband that he was made to sign in some documents for voluntary retirement. Lordship, may kindly come to page 30. To the Commandant then Assam Rifle, prayer for cancellation of voluntary retirement on behalf of so-and-so, that is the petitioner husband. With due respect and honor on the subject above, I, Srimati so-and-so, wife of number so-and-so, Assam Rifle, beg to state few lines for your kind consideration. Thus, sir, my husband is a sole breadwinner in the family, having 2 children who are minor, and our family is entirely dependent on him. My eldest son has just started his schooling, and the younger daughter is only about 3 years of age, and their welfare is also entirely dependent on him. Thus, sir, my husband is a habitual drinker, and because of his drinking habit, he may have failed in his duties and disappointed your authority on several occasions. Thus, sir, my husband is presently on leave from 16/1/2019, 14/2/19, and I have been informed by my husband that before returning home, he was signed in some documents accepting to go for voluntary retirement. Having learned about his action, we have discussed the issue, and he has realized about his wrong decision to go for voluntary retirement and wish to continue in service. Therefore, sir, I would earnestly request your benevolent authority to kindly forgive my husband for his indecisive action and kindly revoke his application form for availing voluntary retirement on humanitarian ground. Sir, once again, I sincerely apologize for the action of my husband and brief before your kind authority to kindly consider my prayer, and for which act I shall ever remain grateful to you. This is dated 18/1/2019. Lordship, application for voluntary retirement resignation was allegedly submitted on 6/11/2018 by the petitioner. Let us know.
6/11/2018.
Yes. As per the documents, although it is not signed by the petitioner late husband, page 18, application for resignation charge. And this representation bring for revocation of that documents was submitted on 18/1/2019 on behalf of my husband. Why I am submitting on this issue, Lordship, by filing affidavit of association by the respondent authorities, that once resignation is submitted, the past service is forfeited unless revoke or representation is submitted within 3 months. That is the law. That is the section and rule 26 of the city special rules. Even assuming that, Lordship, an application for resignation for retirement has been submitted on 6/11/2018, I've submitted application for revocation, cancellation within 3 months' time, provided under Rule 26 of the CC's law. So that is what I mean, I like to project before the Honorable Court.
So before a month,
Yes,
before completion of a month, so 18/11, you have submitted.
Yes, 18/1.
Oh, 18/1.
18/1/19, before completion of expiry of 3 months. Because stand has been taken that since my husband have not submitted any representation for revocation, his past service has already been forbidden. Therefore, family pension is not entitled to the petition. That is the stand of the Lordship, the respondent authorities. So this is the prayer and the representation submitted by the petitioner to consider and to cancel the application, if any, submitted by the petitioner husband. Lordship, may kindly come to page 38.
38.
38 is, Lordship, of my petition.
Yes.
This is the death certificate of my husband, Lordship. Date of date 14/5/2019. Succession, please. Page 39, succession certificate issued in favor of the petition. Page 41, Lordship. After the death of my husband, I can submit a representation to the commanding officer, bring for grant of family pension. Because at the time of the death of my husband also, I was not aware that my husband has been discharged. Because no document, nothing has ever been served to me, Lordship. The contents of my representation will reveal the facts, Lordship.
The discharge order was also not served.
Not served. Till now, till date, I have not received the discharge order. Lordship, page 41, I'm reading page 41. This is representation by me after the death of my husband. Though the so-and-so, subject, prayer for grant of pension, GFIP, so-and-so. Sir, with due honor, I beg to state that my husband, number so-and-so, had unfortunately passed away on 14 May 2019 at Kohima town, Nagaland, due to sickness, after he was suspected to be mentally disturbed while on duty, and authority did not pay any kind of service benefits such as so-and-so till date. As such, we the family members of late so-and-so, wife and the children are in great difficulties. Thus, sir, my husband was enrolled in the government service under some rifle and the rank so-and-so on 29 November 2003 and was under the unit of so-and-so, Manipu, and he continuously served in his capacity for about 16 years under the Defense Department of our country, which entitled him to get all service benefits and pension. Thus, sir, my husband died, leaving behind our 2 children and a helpless widow as his nominee that I am the legitimate wife of so-and-so, and his nominee and his service record, and I am the only person to take care of his 2 children after his death, and that we are facing miserable condition to survive after his death. I therefore earnestly request your kind authority to consider and grant all service benefits to us, and for which act of kindness I shall ever remain grateful to you. I was not aware about the discharge because, see, from this I have not mentioned anything about discharge because I was in dark. Thereafter, Lordship, page 44. Another mercy petition was submitted by the petitioner, page 44. I'm not reading to save time, Lordship. only dated is 8/4/2021, page 46.
But in your para 7, just see, para 7 of your mercy petition.
Mercy
On
petition,
31/1/29, 2019, we were taken by surprise that my deceased husband's discharge order was brought to us.
Not discharge order, only the documents, Lordship. This is a mistake here, Lordship, not discharge order. Only documents, payment order, all these things, Lordship. I made a specific statement in my writ petition that till date I have not received the discharge order. So this was submitted on 8/4/2021. Having failed to get any response, I filed a writ petition, WBC number 164 of 2022. And the letter, Lordship, which I've annexed at page 47. This was about,
in that writ petition.
yes, this was brought by way of an affidavit and that writ petition, Lordship. So I'm reading this impugn letter, Lordship.
Yes.
By this impugn letter, my representation was disposed of. This is order dated 8/5/2023. Heading, Lordship, application for grant of family pension. Refer your application dated 28 April 2021, annex as annexure to writ petition, civil number so, filed by you before the Honorable High Court, Kohima bench, seeking direction to the respondents to dispose of your application and grant family pension in your favor. Number 2, it reveals from the service records of your husband, number so, late so, that he was enrolled in Assam Rifle on 29 November 2003 and posted to then Assam Rifle after completion of basic training. He had submitted an application dated 6 November 2018 to the Directorate General Assam Rifles through Chain of Command seeking discharge, resignation from service on compassionate grounds owing to his domestic problem. He was interviewed by the commandant then Assam Rifle and was informed that on the event of his discharge resignation, he will not be eligible for any type of pensionary benefits. And an undertaking certificate dated 15th November 2018 to that effect was also submitted by him, duly stating that he fully understands that in the event of his discharge at his own request, he would not entitle for any pensionary benefits for the service rendered by him. His application was sent duly recommended by the Commandant Assam Rifle to the Director General Assam Rifle, and his discharge from service was approved by the competent authority with effect from 31/1/2019, White so, Director General Assam Rifle, letter number so dated 15 January 2019. Number 3, after submission of the application for premature discharge from service, your husband did not approach any of his several authorities for withdrawal of his application and his discharge from service attained finality. Lordship, I have referred to the alleged application submitted by my husband and the representation submitted by me for revocation, cancellation of any applications submitted for voluntary retirement, Lordship. And Lordship, is paragraph 3. I'm continuing paragraph 3. On 31st January 2019, accordingly, casualty to that effect was published by then Assam Rebel, part so, order number so, dated 23 January 2019. He rendered 14 years, 10 months, and 5 days, qualifying service in Assam Rifle. Where to discharge, your husband was entitled for final payment of General Provident Fund amounting to rupees so only, and Assam Rifle Group Insurance Scheme accumulation amounting to rupees so only. The same were paid, and intimation to that effect was given to your husband. You write Bay and Accounts Office Assam Rifle letter number so. Paragraph 4. So far as your request to grant a family pension and other relief benefit is concerned, it is intimated that family pension is entitled to the family annuity of a retired employee after his death only if he was in receipt of pension. As your husband was not in receipt of any type of pension due to his ineligibility, as his service was forfeited due to premature resignation in terms of Rule 26, Clause 1 of the CC's role, pension rule 1972, which provides that resignation from service or abuse, unless it is allowed to be withdrawn in public interest by appointing authority, entails forfeiture of past service. Therefore, you are not eligible for family pension and other federal benefits for service rendered by your husband. Lordship, with regard to this Rule 26, Clause 1 of the CC's law, I'm submitting again. The alleged application was submitted on 6/11/2018 by my husband, although signature not valid, Lordship. Against that, as a wife, I submitted a representation on 18/1/2019, bring for cancellation of any application submitted by my husband for voluntary return. That was not considered, Lordship. By now, the authority is coming with a plea that your husband
have they denied receiving that 18/1/2019
no,
in
not,
the
no,
affidavit?
not denied, not denied. Therefore, the stand taken by the respondent authorities under Rule 26, Clause 1 of the CC's rule is not tenable, Lordship. And view of the fact that I've already submitted representation within 3 months as provided under the rules in time, I mean, Lordship. So this is one of the imbued later and praying for quashing the same, Lordship. And page 50 is the order passed in WBC number 164, which was filed by the petitioner. Lordship, may kindly page 51 is the already part. In view of this,
But here it says the petitioners have been granted relief.
yes, because
What
the
was
breer in the writ petition was to dispose of my representation.
Oh, okay. So since it was disposed of,
So that is the text of my case, Lordship. How
the army is also
Not-
governed by CCS pension rules.
yes, Lordship. Assam Rifle, Lordship.
This is not Assam
Assam
Rifle.
Rifle.
Assam Rifle.
Assam Rifle, yes.
Therefore, Lordship, there is stand taken by this Lordship, style,
Yes. We will continue.
Lordship. May napanganak, may napanganak siya.
Ha?
May napanganak.
Hindi ka lang sila.
Ada mo siya, may lang. Case to ini, ulang tuloy.
Yes.
Yes, Lordship. Lordship, may I take Lordship to page 15 of my writ petition. I made 4 prayers. Page 15. Lordship, first prayer, citizen quash the impugned letter dated 8/5/2023. Annexure Q, by which my representation was rejected and disposed of. In that letter, Lordship, impugned discharge order has been mentioned in that letter. Lordship, may kindly come to page 47.
Page 47, yeah.
This is the first impugned order,
Yes.
page 47. And last 3 lines, paragraph 2. Last 4 lines, Lordship. Sentence starts from his application. Paragraph 2.
Oh,
Under
Chichi. Para 2.
Right hand side, sentence starts from his
His
application.
application was sent. This one.
Was sent duly recommended by the Commandant and Assam Rifle to the Directorate General Assam Rifle, and its discharge from service was approved by the competent authority with effect from 31/2019 by Director General Assam Rifle, letter dated 15 January 2019. This discharge order was not available and it is not available now also with the petitioner. Therefore, the prayer number 2.
They have not annexed in the affidavit also.
I'll come to that question. Prayer number 2. Impugned letter dated 15 January 2019. I have not mentioned anything about annexure because I have not annexed because I was not aware. And that document was not available to me. Prayer 3. Citizen quashed the application dated 6/11/18 and 6/11/18, which I have referred to, Lordship, the annexures.
Those applications made by the,
Alleged
allegedly
application.
made by the
Petitioner
petitioner's
husband. And undertaking, there are 2 undertaking, Lordship, which I have pointed out to the Lordship. Undertaking which was allegedly executed when the petitioner husband was on leave at home. And
undertaking,
yes, Lordship. Direct respondent to grant family pension to the petitioner with effect from 14/5/2019.
14/5 is the date of death.
Yes, and other consequential benefits from 31/1/2009. 31/2009.
31/2019.
Yes, 19, Lordship. So, Lordship, fortunately, the discharge order is annexed in the affidavit in opposition filed by the respondents, page 21. This is 15 January 2019, mentioned in the letter, impugned letter, Lordship. So I'm challenging this discharge order also, Lordship. So, Lordship,
Yes.
Lordship, what is the basis of discharging the petitioner husband from service, Lordship? Firstly, Lordship, the alleged application dated 6/11/2018. Which was allegedly signed and submitted by the petitioner husband. Whereas signature is different. And the second, Lordship, the second basis in issuing the discharge is the undertaking executed by the petitioner husband. 15/11/2018, and 16/11/2018, which was unfortunately executed when petitioner was on leave at home at Nagaland.
15/11 and
16/11.
16/11/2018.
He was on leave at home, Lordship. Therefore, my submission is that, Lordship, discharge has been done based on the manufactured documents. And mischief has been committed by the authorities.
Otherwise, if it is suppose it's a voluntary petition, then what is the qualifying length? 10 years.
Not because it's a case of death, Lordship.
Oh yes, now he's
It's a
passed
case of
away.
death, yes. So 1 year, continuous service. Therefore, Lordship, the basis of discharging the petitioner without petitioner benefits is totally illegal and not tenable in the act law. I may be allowed to read two paragraphs from my writ petition, paragraph 16 and 17. Paragraph 16, Lordship. That the petitioner begs to state that in their process of alleged submission of application for discharge and undertaking for resignation, where the petitioner late husband was made to sign in a ready-made format has been done behind the back of the petitioner as well as her late husband, which is apparent on the face of the record. The mischief act of the respondent is more clear from the documents produced in the earlier writ proceeding, where the petitioner late husband was made to sign in application format, where it has been mentioned as request for discharge, whereas in undertaking it has been mentioned as resignation. Such an action of the respondent authorities towards a personnel who was mentally unstable is totally uncalled for which the interference of the Honorable Court is called for. Last paragraph, 17, Lordship. That the petitioner begs to state that by the impugned letter dated 8/5/2023, the claim of the family pension has been denied inter alia on the ground that the petitioner late husband did not approach for withdrawal of his application for discharge from service, and therefore the discharge of her late husband from service attained finality on 31/1/2019. That is the date the petitioner late husband was allegedly discharged. It is on record that when the petitioner late husband returned home for his leave period granted with effect from 16/1/2019 to 14/2/19, she was informed by her late husband that he was made to sign in certain documents for voluntary retirement. The petitioner immediately, sensing some foul play, taking advantage of her husband's mental inability, submitted to application bringing on behalf of her husband for cancellation of the application for voluntary retirement if signed by her husband. It is stated that the petitioner was compelled to submit a representation on behalf of her husband in view of his mental disability. Therefore, the stand taken by the respondent authorities in the impugned letter dated 8/5/23 is totally misconceived, and the grounds for denial of the claim for family pension is not tenable in facts and circumstances of the case. Worship me, kindly come to the stand of the Respondent Union of India. Lordship, stand starts from paragraph 2. I'm reading four paragraphs, Lordship. Paragraph 2E of the affidavit of opposition, page number 2. This is the stand of the Union of India. That at the very outset, the answer demanded back to submit a brief facts of the case as here under Ebony. Number so rifleman General so was enrolled in Assam Rifle on 29/11/2003 and posted to then Assam Rifle after completion of basic training. He submitted an application on 6/11/2018 to the Directorate General Assam Rifle through provisional for discharge resignation from service on compassionate ground owing to his domestic problem. He was interviewed by the Commandant then Assam Rifles and was informed that in the event of discharge resignation, he would not be entitled for any type of pension benefit and an undertaking certificate dated 15/11/2018. To that effect was also submitted by him, duly stating that he fully understands that in the event of his discharge, at own request, he would not be entitled for any pensionary benefit for the service rendered by him. His application duly recommended by the then Commandant then Assam Rifle was processed to Directorate General Assam Rifle, and his discharge from service was approved by the Commandant Authority with effect from 31/1/19. White so dated 15/1/2019. B. After submitting his application dated 6/11/2018 for premature discharge from service, ex-rifleman Shri so did not approach any of his several authorities for withdrawal of his application, and his discharge from service attained finality on 31/1/2019. Accordingly, Schedule D to that effect was published by so. He had rendered 14 years, 10 months, and 5 days qualifying service in Assam Rifle. Lordship, here, as I've submitted earlier, application was allegedly submitted on 6/11/18, as a repetition, Lordship, and cancellation was submitted by the petitioner on 18/1/19 within time, because to submit an application for cancellation should be within 3 months as per the Rule 26 of the city's rules. I'll refer to later on, Lordship. I'm not waiting C. D, Lordship. Page 4. An application dated 25/1/2019 was received. That is the received date, which I have submitted on 18.
On that 18th.
Yes. From the petitioner, Srimati so, wife of ex-so, seeking cancellation, revocation of the discharge order of her husband, ex-so. Her application was examined by the competent authority. However, her request was not accepted to as her husband had not submitted any application from his end for withdrawal of his application for premature discharge within the stipulated time, and also his discharge had already been attained finality on 31/1/2019. Another application dated 19/19 was received at Directorate General Assam Rifle from Srimati Marina Ree with request to grant family pension in her favor, stating that her husband had expired on so. Her application was examined and found devoid of merit in terms of Rule 26, Clause 1 of the Central Service Pension Rule 1972. Accordingly, pension was not granted to her. However, she was found entitled for final payment of provident fund amounting to rupees so, and Assam Rifle Group Insurance so, after deducting of so balance of so. The same were paid to her and intimated white payment so. F, Lordship. So far as her demand for grant of family pension and other retirement benefit is concerned, respondent humbly submits that family pension is entitled to the family of an employee of his after her death, if she in receive of pension. That is totally misconceived, Lordship. In the instant case, ex-so was not receiving any type of pension due to his resignation with effect from so.
This is only for pensioners.
Yes.
If a pensioner dies.
Yes.
But if someone in service dies, then?
Yes, Lordship. It is on request on compassionate grounds. Hence, the petitioner is not entitled for family pension under provision of Rule 26 of the Central Service so 1972, which provides resignation from a service or both unless it is allowed to be withdrawn in public interest by the appointing authority and thus forfeiture of past service. Withdrawal may be permitted by the competent authority before actual execution of resignation by so. However, X so had not submitted any withdrawal application. That facts, Lordship, I have already made submission about the submission of representation by the petitioner against the application on 18/1/2019. Which already read. Yeah. And Lordship. Paragraph 8 of the affidavit, Lordship. That is, statements at part 7 are false and denied. The respondent submits that the petitioner husband had submitted an obligation dated 16/11/2018 for premature discharge from service and commissioner owing to his domestic problem to his company, and the same was forwarded to Badaling Headquarters Record Branch, then Assam Rebel, by his company by later registration. He was interviewed by the commandant, then Assam Rebel was informed that in the event of discharge resignation, he would not be entitled for any type of missionary benefits, and an undertaking certificate dated 15/11/2018. To that effect was also submitted by him, duly stating that he fully understands that in the event of his discharge, at his own request, he would not be entitled for any missionary benefit for the service rendered by him. His application was duly recommended by the commandant, then Assam Rifle, was processed due to the Directorate General Assam Rifle, and his discharge service was approved by the so. Moreover, the representation dated 25/9/19 submitted by the petitioner due to the commandant, then Assam Rifle, was received by the unit on 7/2/19. That is, after discharge of X so. Hence, no action was taken by respondent in response to her application, as her husband had already proceeded on discharge by her to receive our application. Lordship, here, Lordship. The petitioner husband served the department for nearly 15 years. Now, a prudent man cannot avail voluntary pension without any financial benefit after serving for such long period, Lordship. However, by the documents annex, which is a doubtful document that petitioner husband admitted for voluntary pension without any pensionary benefits, Lordship. It is beyond human imagination that a person, after rendering for 15 years, decided to voluntarily discharge from service without any pensionary benefits. And from the action and the conduct of the respondent authorities with regard to application, undertaking allegedly executed by the petitioner husband, there's something wrong, mischief, foul play, Lordship.
Undertaking certificates are 15/11 and
16
16/11.
years during the leave period. And both embroidery signature are not same, Lordship. Even by our naked eyes, a different sheet, totally different. Therefore, taking advantage of his mental disability, all this mischief has been committed by the respondent authority to deny the pensioner benefits. So, Lordship, taking into consideration of all these facts and the action resorted to by the Assam Rifles, Lordship, it is a fit case where this honorable interference is called for. Lordship, lastly, I'm referring to the CC's Pension Rule 26 with regard to resignation. Submission of application for withdrawal is within 30 days, Lordship. Yes, 136. Lordship, 3 months, please.
Forfeiture of service.
Yes.
26.
And withdrawal is 90 days, 3 months.
The result of the permission to withdraw the resignation is not more than 90 days.
So I have submitted my application for withdrawal within 9.
This before it is approved, Lordship. Before approval.
Between the date on which resolution becomes.
But I was not aware about all this application and undertaking. Only after filing affidavit of association and the earlier writ petition, I came to know about this. And so far as the family pension is concerned, Lordship knows, Lordship Mechanical Bureau section, Rule 54 of the CC's rules. In case update, 1 year, continuous service is sufficient.
No, that is, the rule is there. What is the
Rule 54, Lordship, yes. My humble submission is the alleged application and the undertaking executed by the petitioner husband, which is a part of record in the affidavit, is not tenable in the IF law. The same should be interpreted with, and direction may be issued to the Assam Rifles to grant family pension from the date when the petitioner husband expired. So I conclude my submission, Lordship.
Any authorities on this
Lordship, it's a rare case.
withdrawal and
I tried my
withdrawal
best to find out some authorities, but then there is no such authorities because it's a rare case, Lordship.
this section 26, rule 26, on rule 26.
Rule 26 of CC's rules. That is a Lordship.
Because interpretation of rule 26 is also required.
Is they are
Because-
saying
because
that
now they
the
are saying that
petitioner husband did not submit.
It is
It is
before the acceptance.
Yes.
That is here they are saying it should be before the acceptance of the
But then,
withdrawal.
Lordship, the petitioner husband as well as the petitioner was in dark about application, about the undertaking, which was brought to the notice only in the year 2022 by filing affidavit of opposition by the Union of India.
No, we'll look into that aspect also, but still,
Yes.
if we can find anything on this 26.3, anyway, yes.
So I forward submission, Lordship.
Okay. Yes.
Lordship, the procedures are alleging fraud, Lordship. If I might come to my affidavit of possession at page 18. And my affidavit in possession, page 18. Lordship, this is a request for resignation from service at good request. This has been signed by the petitioner's husband, late husband, and this has been witnessed by 2 persons, Lordship. So if any forgery is conducted, then this can be verified by the witnesses, whether he has signed or not. So witnesses, Lordship. You might have seen it, Your Lordship.
Otherwise, signature is not telling.
Signature every signature does not tally, Lordship. Even my signature also does not tally sometimes. But this can be verified by the witness. In the other undertakings also, in the other pages also, signatures are tally. The same signature. Annexure 1, Annexure 2, same signature, Lordship. Annexure 3, Annexure 2, page 20. Same signature, Lordship. Page 18, 19, 20, same signature, Lordship. And the witness, name of the witness are also given.
But if he was mentally unfit,
He was not. He is not
won't have-
mentally unfit, Lordship. He was he's a drug alcoholic. If my Lordship may kindly come to my affidavit at page 6, para 5 of my affidavit, Lordship. 5. That with regard
para
to
6, para 5.
para 5, page 6, para 5. My affidavit.
Yes.
That with regard to the statement made in para 4 of the petitioner, the answering deponent submits that due to alcohol dependency syndrome, he is an alcoholic. The petitioner's statement was initially placed at low medical category, that is S2, TEM. This is a medical term, Lordship, with effect from 21/8/2015 and downgraded to S3 with effect from 7/2/2018 and subsequently upgraded to S2 TEM. So he is now medically fit as per this report, medical report. He is not mentally not, but he is a alcoholic. Well, Lordship, the petitioner is a government employee. It is the government employee himself who has to sign his resignation order or withdrawal letter, but he has never signed any. He has never signed the withdrawal letter. It was the petitioner, his wife that has signed on behalf of the late husband. Whether that is applicable can be appropriate, Lordship, because he's a government employee. It is the government employee that has to sign in all the documents, but he has not signed. It is the wife who has signed. So it is whether it is the petitioner or his wife who is a government employee. So that means the petitioner is forcing the government, his husband to serve. In spite of his resignation, his wife is compelling his husband to serve. It is not the petitioner who has signed, it is not the government employee who has signed, but it was the wife. It should be the concerned government employee that should sign. Lordship, I'll just read out some facts from my affidavit in the possession only.
Acha, what about your para 7? In your para 7, you have stated that you have granted him leave with effect from 13 November 2018 to 31st December 2018.
Yes.
Your affidavit para 7.
Para 8.
It is your own affidavit. Para 7 of your affidavit. The answering deponent submits that the petitioner's husband was granted
Yes,
leave.
Lordship, that's why I come
With
to
effect from
page 9, para 9,
to 31.
para 9, Lordship, para 9, page 9, para 9.
Yes.
That with regard to the 7 made in para 8, the answering deponent states that on 15/1/2009,
No, this is another one because he was granted leave on different occasions at different times. So this is one, of course, 16 January to 14 February is one.
Lordship, I think there must be some mistake because in the original parawise comments, which was here, it says the sanction, he was sanctioned 10 available leave, 60 days leave, with effect from 16/11/2018. So on 16/11, he was present in the battalion. This is, Lordship, I'm showing you the original paragraphs. It says he was granted leave on 16/11/2018. So that means on 16/11 he was in battalion, which proves that. I'm sorry for the typing method.
But in your
Yes,
affidavit,
Lordship.
you have stated
This
13
I have said it in my
13
affidavit, Lordship.
November
This is
18 to 31st December.
this is not so in the paragraph, my Lordship. The original paragraph, my Lordship. Can you verify?
Reply to my paragraph 6 may be Pedro's Lordship. Reply to my paragraph 6 of the writ petition.
No, that's right, that's what I'm looking at.
Yes.
Para 7 of their affidavit. So there, they have themselves stated that he was on leave from 13 November to 31st
That is why,
December.
that is the mistake of the council, Lordship. Otherwise, the reply of
Para
the
6.
authority is different.
Leave was granted on 2 occasions.
Yes.
In the year 2018 and in the year 2019.
One was the 13 November to 31st December.
Yes.
And one was 16 January to
Yes.
14 February 2019.
So 15/11 he was in the battalion, Lordship. When he signed the discharge, not the discharge.
This is not telling at all.
16/11.
What they are saying is 16 November 18 to 14 January 2019. 16 November 2018 to 14 January 2019.
Okay.
There's something wrong. Because if you go by page 27 of the writ petition, there it is, the
13.
letter is signed on 13/11.
Yes.
So 13/11 to 31st December 2018. So which is telling with your para 7?
Yes.
Yes, this is prepared by me. That was the was reply that was given by the authority. I was watching if this the tomorrow I can verify it.
You kindly verify, because if he was on leave from 13/11 to 31st December 2018, as you stated in your para 7, Then he could not have signed that undertaking on 16/11.
Let me come off the problem and I'll check the dates. I'll check the dates with the original powers, comments and my affidavit.
And then you see that letter, that annexure also, that annexure, it is stated there in the annexure 2, but I cannot find that annexure 2. Whatever, whichever that is.
Of my affidavit, Lordship.
No, there in the parawise.
Annexure 2 is undertaking.
Oh, that is the undertaking.
Yes, Lordship. Yes, that is the undertaking.
No, because there it says letter dated 6 November, no? It says letter dated 6 November, something.
That is a request for resignation.
Oh, 6 November?
Yes. 6 November is request.
Okay. You just check up those dates, otherwise. 13.
Tomorrow, Lordship, or?
Okay, tomorrow.
I'll take, that's just to check out the dates. And Lordship, this is the original.
But otherwise, you complete your submission.
Yes.
There's something wrong, because what the petitioner is saying and what you're saying is very different regarding the dates of leave. Because if you're saying 13 November to 31st December, you're also agreeing to that, isn't it?
Yes.
That he was on leave from 13 November
Yes.
18 to 31st December 2018. And again from 16 January 2019 to 14 February 2019. Because there in the
all
parawise,
my submission is from para 2 to para 2A to para 2A to F only. 2 to F, that will be my submission
para
also.
2
A to F, that is page 6.
to F.
As far as withdrawal is concerned, Lordship, withdrawal can be done only before the approval by the competent authority. Dates may be there, but once it is approved, that cannot be withdrawn under the CCS rules. So
Can be only before the approval.
before the approval, yes, there is a date, certain date given, but before the approval. Here, it was already approved. It was already approved. Thereafter, he has withdrawn, and the application was not signed by the concerned employee itself. It was signed by his wife. Whether the wife can be termed as a government employee, Lordship, and whether the government employee who really want to continue with his service or not, it is the government employee who will sign his resignation letter or withdrawal letter or anything. But his wife, on his behalf, he cannot sign any documents. Even with his approval, he cannot sign. It is the government employee that has to sign. And otherwise, other than the flexibility of the dates, Lordship, my submission, as I said, from respondent, on para 2A to F will cover my submissions. And I have said from para 5 that he is not mentally ill. Para 5, I have said he is not mentally ill. He was a drunkard. His mental stage has been improved from category. This is a medical term, but it says from category S2, downgraded to S3, and subsequently upgraded to S. As we're not saying anything about his mental health. We are saying about his alcoholic effect, Lordship. So he was an alcoholic, that is admitted, Lordship.
Para 5, no?
Para 5, Lordship. These are medical terms, so I do not know what it says also.
Because in your parawise comments again, it is stated the leave is from 16 November 2018 to 16 January 2019.
16/11 on that day.
No. What I mean is why the discrepancy is
Yes,
because
right.
whereas the petitioner is saying that it was from 1 leave was from 13 November 18 to 31st December 18. The other leave was from 16 January 2019 to 14th February 2019. Okay, so you are certain.
That is the part applicable in my writ petition, because leave certificate is already there. Leave
Yes,
certificate.
yes.
Yes.
But
so they cannot deny.
no, in their paragraph,
Yes.
something is wrong.
Yes. So let me verify this, the voice comment my affidavit.
That's
as
why,
well as,
because you
leave
check out,
certificate.
compare with the petitioner's documents.
Yes. The leave certificate.
Okay, we keep it part third, just go.
Yes, Lordship.
Part third, and then just to clarify the.
Just to clarify the date, Lordship, along with the
Panel counsel for the petitioner, Mr. Rawati Jamil, as well as Mr. Young Rawati Leonard CGC. Part third to be listed tomorrow.
Next one.
For hearing, item number 23.
Yes.
My pleasure, Lordship. Lordship, the conducting counsel will be appearing through VC from Gauhati.
I am here, Your Lordship.
We cannot see you. Oh, okay. Yes.
Your Lordship.
Yes.
Your Lordship, the coordinate bench of this honorable court had its order dated 27/8/2025, Lordship. Wherein Lordship directed me to appear and cooperate with the investigation officer, Lordship, if possible, if necessary, Lordship, through video conference, Lordship. So, Lordship, by compliance, the Honorable Court order dated 27/8/2025, Lordship, wherein I cooperate with the investigation authority through conference, Lordship, video conference, Lordship, that is on 4th of September, Lordship, 25. But, Lordship, I did not able to submit the bail bond which was enumerated in paragraph, Lordship, order dated 27/8/2025, Lordship. Only because of that I am unable to submit the bail bond. That is why, Lordship, when I cooperate with the investigation officer and asked me to submit the bail bond for, by way of another person, Lordship, then, Lordship, IO asked me to my personal attendance may be required to execute the bail bond. That is why I could not submit the bail bond, Lordship. So, Lordship, and other hand, Lordship, I have cooperated with the investigation proceeding, Lordship. Now, that is the difficulty arises only because of that, Lordship. There, my personal threat, Lordship, from the underground organization. That is why only I am unable to went to the concerned police station and unable to submit the bail bond. Despite, by considering my reason, Lordship, Honorable Court, it is absolutely right, the Honorable Court order dated 27/8/2025, wherein opportunity was granted to me by assisting the concerned jurisdictional police authority. Despite of the same, I am unable to attend their, Lordship. That is the difficulty arises, Lordship.
No, I don't understand. Because the court has clearly said that the needful can be done by the investigating authority of the concerned territorial jurisdiction. So basing on this order, you could have sought some security, because without executing a bail bond.
No, my Lordship, I have an objection here.
That
My Lordship, what happened is that actually it is not fully cooperation also. I have an objection here, Your Lordship. As per the
Do you have
direction.
any information from the IO?
Yes, Your Lordship. I have, as per the direction of this Honorable Court, the IO gave a text to the council also that a video conferencing will be held on 4th. So accordingly, it was intimated to the council. I think the council also intimated to the accused. After that, the IO says that in order to satisfy, he again texts the accused on the day that we will be having a video conferencing on 4th. But at the time, the appointed time at 11, when he went for video conferencing, he was on the vehicle, Your Lordship, on a running vehicle. So how
No,
is
no running
he
vehicle.
was on a running vehicle, Your
No
Lordship.
running vehicle, Lordship.
No, Your Lordship, Your Lordship.
Yes, let your
Let me complete, Your Lordship. Let me complete. At least let me complete. If you have any objection, you can do after my submission. So on a moving vehicle, it seemed he was going somewhere. That was not certain, but he was on a moving vehicle and he did the video conferencing on the vehicle. Is it proper, Your Lordship? And the IU could not able to make a cannot able to make a statement. And the IO said, okay, if that is the case, at least we are going to provide a security. So at your house, we will come and we will take you, and even going back also, we will provide you with a security. So at least come and we will execute. But he did not reply, and the line went off. After that, what happened is that he called even yesterday, repeated after that, because video conference could not be completed. The IO repeatedly called after the next day also, and even yesterday it seems, the IO called, but he did not respond, Your Lordship. Your Lordship, here the court.
case where that.
Yes, this honorable court cancelled the bill of non-cooperation. Your Lordship.
I don't think we appreciate the
Yes, Your Lordship. Yes, Your Lordship. He is taking the right of the law. We should not allow him to take advantage of the law. He's taking the right. We should not allow him to take advantage of the law.
And
Your
even
Lordship.
the interim was given on the condition that you execute the bail bond.
Yes.
That is not executed. So which means the interim is not there.
He's not at all
Because there is a
sincere enough.
condition put by this court that the interim is granted on execution of the bail bond. So when you have not executed the bail bond, where is the interim? There is no interim as of today.
Your Lordship, being a law student, it is absolutely and very much clear that
How
our
can I
bound
go?
duty, Lordship, to submit and bail bond, Lordship.
No,
But
you-
that's
Your
why,
Lordship,
Lordship,
you cannot
I
go.
will direct the police to provide security. You go and execute. You go and execute. Heard Leonard
No, Your
Counsel,
Lordship,
please.
my humble at least my objection may also be recorded, because
that
Your
also
Lordship,
will say, yes,
he is taking completely, he is abusing the law, Your Lordship, taking delay in
that will
tactics.
record.
He came with a transfer certificate, transfer petition. It was dismissed by the court because it wasn't under a provision. Then the court granted this time that at least okay, and I was also accommodated.
When
Let
was
it be
that?
video
Fourth?
conferencing.
absolutely
It was on fourth.
admitted fact, Your Lordship. But
Cooperation means does not simply mean
by assisting
it should be with sincerity, Your Lordship. It
No,
should be with
I'm not
sincerity.
about the argument about that part, Lordship.
No,
It is
no, Your Lordship.
absolutely right, Lordship, duty bound. Being a law student, I know Your
His
Lordship.
conduct does not show sincerity at all.
But Your Lordship, the
And the IU is facing harassment, Your Lordship,
police station, Lordship.
running here and there.
Absolutely right.
Your Lordship, it should not be allowed.
Contradictory
I
statement.
feel that interim should be cancelled, even interim, and
Admitted
this bill should be
Admitted
cancelled.
fact, Lordship, but Lordship, opportunity may be granted and please be direct the local police station, Lordship, at least cooperate, Lordship.
No, I think I'm going to dismiss this application.
Yes, Your Lordship, you yourself has actually dismissed because of
Other hand,
non-cooperation.
Lordship, my Article 21, Lordship, that is a fundamental right, Lordship. That is the High Court and Supreme Court has a bounden duty to protect the fundamental right. That is why absolutely right, Lordship, Honorable Court has considered.
What about the corresponding duty on your part? You also have a duty to cooperate.
Yes.
Lordship, that is why, Lordship, through video conference, even
You
if
invoke jurisdiction when you're cooperating.
We have actually made a submission even last time, Your Lordship, that we will provide security.
in
And
the
he's not willing.
investigation officer itself, Lordship, wherein he compelled me to again and again to make a compromise, Lordship, and settle the dispute amicably. It is absolutely right, Lordship. There is a setup. Our statute has set up such a resolution, such a way, Lordship, mediation and such a Lordship. The authority can ask me to compromise, but IO has no right, Lordship. IO has a bounden duty
We
to
can take
investigate
due
the matter.
consideration
Apart from
taking the
investigating, Lordship,
threat he is receiving. Taking the threat he is receiving, you also have consideration, but no.
Okay, I'm passing order.
Yeah.
Heard Learned Counsel, Mr. Mintu Saikia. Stop. Also heard Learned Counsel for the Learned Public Prosecutor, Ms. Livika. Stop. On 27/8/2025, this court had granted interim bail to the petitioner on execution of bail bond of ₹20,000 with one surety of like amount to the satisfaction of the arresting authority. subject to the condition that he shall cooperate with the investigation and shall appear before the IO through electronic mode if necessary. Stop. It was also stated by this court that for any apprehensions of security of the petitioner, the needful can be done by the investigating authority of the concerned territorial jurisdiction of Nagaland. Stop. It was therefore directed that the petitioner shall appear before the IO of the case through electronic mode if necessary on 6/9/2025. Stop. Learned counsel for the petitioner has submitted today that the petitioner could not execute the bail bond as directed by this court, but that he had appeared through electronic mode on 4th September 2025. So it is therefore prayed that it is therefore prayed by the learned counsel for the petitioner that he has been cooperating with the investigation, and therefore this bail interim bail granted on 27/8/2025 may be made absolute. That's your submission,
Yes.
isn't it?
Yes.
Made absolute. Stop. Per contra, the learned submits that the petitioner has not been cooperating fully with the investigation.
With sincerity, Your Lordship.
Has not cooperated with the investigation with sincerity, as even on 4th September 2025, when he appeared through electronic mode, he was traveling and he was in the vehicle only.
On the vehicle, Lordship, but not driving that
vehicle, and therefore the IO could not examine him properly. Stop.
And on the virtual mode, Your Lordship, the IO asked him that we will provide you security, and so you give us a date, we will provide. But he was not willing, and the line got cut off, Your Lordship, after that.
The petitioner that he will be provided security to come to the station to give his statement. Stop. However, the connection went off, and the examination could not continue further. Stop. General PP also states
Your Lordship, thereafter also since statement could not be completed, the IO make a call after that also on the next day and even yesterday, that is on 10th also, but
thereafter,
no response.
The IO, since the examination could not be completed, the IO made call the next day, and also on 10th, and also on 10/9/2025, but the petitioner could not be reached.
He did not receive the call, Your Lordship. He did not receive.
Your Lordship, my statement can be recorded, Lordship. IO has repeatedly compelled me to make a compromise and come, Lordship, amicably settle this matter. Your Lordship, our statute has set up, Lordship, there is a mediation center is there, Lordship. Apart from this, Lordship, IO has communicated to my client, Lordship, and he repeatedly, Lordship, asked him to make a compromise between the parties. IO has no right. That is the illegality done by the IO, Lordship. If Your Lordship asks the IO to appear before the court, Lordship, entire fact will be the crystal clear. That is why, Lordship. So IO have Lordship, vested interest in respect of this case, Lordship. Definitely, Lordship.
So the local jurisdiction of the
And if possible, Lordship, may can be granted me, Lordship, to submit the execution of bail bond with before the local police station. I am ready to cooperate. That is why, Lordship. By tomorrow or any other date fixed by this court. Then, Lordship, it may be forwarded by the local police station to the concerned IO, Lordship.
The IO first record your statement properly in person.
Yes.
Okay, then we'll examine this case. Then what did I say? The IO again tried to, but he did not receive the call. But the petitioner did not receive the call. Stop. The learned public prosecutor further submits that the petitioner has not executed the bail bond as directed by this court, And therefore, she submits that this application may be dismissed as the petitioner has not cooperated with the investigating authority.
I also give a message on Saturday.
After considering the above submissions, this court is of the view that the petitioner has not cooperated fully with the investigation, and he has also not executed the bail bond as directed by this court on 27/8/2025, and thereby violating the conditions set by this court. Therefore, the investigating officer is directed to provide security to the petitioner, and the petitioner shall accompany the investigating officer and the police personnel, and what is the PS? Which PS?
Dipupar PS.
And
Dipupar PS.
Dipupar.
Yeah,
And
Dipupar
report
PS.
his
41 out.
at the Dipupar police station.
A
Dimapur.
specific date may be given.
On, yes, we'll give a date.
This may be the last chance. Your lordship, it has
Yes.
become too much, your lordship.
Acha, give a date. The police will come and pick you up.
Yes.
Give a date.
আজি আপোনাৰ স্যার 11 তাৰিখ
On 18, your lords.
18th.
Yes.
Okay, on 18th September. On 18th September, give a timing also. Okay?
Yes, I mean,
18th September at 1 p.m.
Yes.
At 1 p.m. So thereafter, the investigating authority shall record the statement of petitioner and submit the same to the learned public prosecutor. List on 22nd. 22nd. List on 22nd September for further hearing. Yes.
much obliged.
Please, your lordship.
Oh, yes, wait, one more line. Police station and report his statement and also execute the bail bond. Yes, and also execute the bail bond as directed by this court. Yes.
Please, your lordship. My sincere apologies for my lordship for calling my matter once more again, your lordship. But if I may be allowed to make a mention, item number 25, your lordship. Your lordship. While making my submissions, your lordship, I forgot to include my interim prayer, your lordship.
Oh,
Yes, your lordship. There's an interim prayer, your lordship.
but you didn't pray for it when you were submitting.
Yes, your lordship. So,
What interim prayer?
to maintain a status quo between the parties, your lordship, until the disposal of this case.
Okay, in item 25, okay, just say that the parties are directed to maintain the status quo till the next returnable date. Just add that one line.
Your lordship, if the interim could be effective, your lordship.
No, that's why till the next returnable
Yes,
date,
Lord.
status quo.
Yes, your lordship. Obliged.